May it please, my lord. My lord, item number 45, my lord. It may kindly be taken up after vacation, my lord. 45.
On request of learned counsel for the petitioner,
একজন করে দিলাম,
let this
CDS
matter be listed after vacation.
My lord, we are on interim, my lord. Kindly
The
please take.
interim order shall continue till next.
Highly obliged.
CD available madam, CD
The case diary,
be retained madam.
which is available, may be retained till next day.
45.
Highly obliged.
May I please?
Yes, sir.
I beg to mention item number 77 for upgradation, my lord. If it is not taken up today, it will become infructuous. Maybe taken up at 2 p.m. or at
No,
the-
how it will be,
because it is an IA for suspension of sentence.
no,
And
it will still be relevant.
No, my lord, he is the date is fixed for surrendering is 18. At 2 p.m. or as the last item,
Okay, as last item.
my lord.
Lordship, item number 53, adjourn for the
Yeah, item.
Heard,
53.
heard Miss S. Devi, learned
CD
counsel for
available.
the petitioner.
CD
CD is available.
Matter may be fixed on 19th.
Learned counsel for the
19th.
petitioner who prays for an adjournment. The prayer is allowed. The case diary which is available may be retained till next date. Let this matter be listed
19.
on 19th of January. The interim order, you are on interim? You do.
I propose it.
No, then remains silent.
Interim.
Okay.
Obliged. May I please, your Lordship? Criminal petition number 41 of the 2020, Santi Kumari Das versus the state of Assam and 5 others may be fixed on 19th January due to urgency. 19th January.
What urgency?
Lordship.
What
What
urgency?
urgency?
Actually, a special case is pending against Santi Kumari Das
No, it is for motion.
for hearing.
No, then you pray before registry. It is a matter fixed for hearing.
Yes.
Then you
2020 madam, yes. Registry request করা।
pray before registry.
Obliged.
I beg to mention item number 33. I think CD is not available.
33 CD 9. Yes, but CD not available.
Heard
Ms. Dipuri.
Miss Lee Puri, learned
Yeah.
counsel for the petitioner.
22nd.
Learned additional public prosecutor prays for another date for producing the case diary. The prayer is allowed. Let this case be listed again on
22nd my lord.
22nd January for case diary.
May I beg to mention item number 43, madam. This matter may kindly be taken on 19th, madam. I am on interim, madam.
Heard Mr.
CD
A.
available.
A.R. Talukdar,
Madam.
learned counsel for the petitioner who prays for an adjournment.
43.
The prayer is allowed. Let this matter be,
CD.
CD is available.
My lord.
Let this matter be fixed again on 19th. The case diary be retained till next
19th.
date.
Obliged,
The interim order shall continue till next.
obliged. Yes. Yes.
May I please, your lordship? My lord, with all respect, my lord, item number 69, my lord. Therein, my lord, with all respect, my lord, this matter, this has been placed before your lordships because of the Supreme Court judgment, my lord. If a similar matter is disposed of by a particular bench, it has to go to that bench, my lord. With all respect, my lord. Can it be, my lord, taken up around 3 o'clock, my lord? 69, it did not reach. All
No.
others have been granted on merit, my lord, on law as well. My lord.
It will go before.
It came before a different bench, my lord, because lordship disposed of us exactly same or similar matter, my lord, on the same subject, my lord. The coordinate bench, my lord, has sent it because co-accused has been granted the privilege by your lordships, my lord, because of a Supreme Court judgment, my lord, cited by the NCP, my lord. Can it be taken up at 3, my lord, with all respect, my other it would not reach, my lord. Parity, my lord. It will take 1 minute, my lord.
After other bail hearing matters.
My lord. then it may not reach, my lord. And if your lordship permits, only one liner, my lord, it will take
But-
1 minute.
But all bail hearings are similarly.
Important, if that is a fact.
Similarly.
4 years inside, my lord. Others have been granted the privilege on law and on facts, my lord. Same facts, same law, my lord.
After other BL.
After other,
After-
after other. Highly obliged, my lord. Highly obliged, highly obliged.
My pleasure, Lordship. Item number 28 here, Lordship. Admission matter. After vacation, your Lordship, 19 years.
Heard, Mr. On request of learned counsel for the petitioner. 28, who is for the opposite
Now we are, Madam.
Government.
learned counsel for the petitioner? Let this matter be listed after vacation.
19.
No fixed date,
19.
after vacation. 19, we have lot of.
A lot of.
22 years others is behind the bar, your Lordship, challenge.
20,
22 years.
20 is holiday.
22
22nd.
years. 22nd.
26 pisot. 24th.
20. Another period, your Lordship, yesterday matter, item number 75. Is in the government servant, there is no interim, your Lordship, it is there. You take out before rising, your Lordship.
Yesterday's matter, how you can mention now?
No, your Lordship,
To-
listed, your Lordship.
Today listed
It
75.
is 75 item, your Lordship.
Okay.
Because government servant, there is simple issue also for 20 years. First implicated him.
We'll see how much we can reach.
Before rising, your Lordship, small issue, your Lordship. Issue is very small.
Let us see. We'll try to take it up.
Except there is no interview, the government servant is suffering. your Lordship. Also implicated in 420 years and 376.
It is an anticipatory bill.
Anticipatory loss.
Anticipatory bill, then you have to wait.
And
Interim is
interim
not rare. your Lordship.
Or
Yeah,
No,
it's-
still, you are free person till
No,
now.
yeah, the government servant is suffering problem because issue is falsely implicated. him.
No, all matters here are anticipatory bail or bail matter. To give precedence to you, there must be a valid ground. Because others are also waiting. Merely because others are not mentioning. Their right you cannot supersede them.
No, I have.
Therefore, you have to wait.
And playing with the government, sir, otherwise I.
We will try to take it up.
That's right.
May I please, Lordship. My lord, I am in custody since 122 days as on today, Lordship. Lordship may kindly see FIR at page 10,
It is a
Lordship.
charge sheeted case.
Charge first charge sheet has been submitted, Lordship. I am sole accused in the case, Lordship. I am thoroughly interrogated. Investigation has been thoroughly done, yet first charge sheet is submitted, Lordship. I was arrested on 13/9, forwarded on 13/9. And the CS CS was submitted on 31/10, Lordship. That is after 59 days of my arrest. The part charge sheet was submitted. As on today, 122
Where
days.
is the charge sheet?
Lordship may kindly see at page 13, Lordship.
Where is the mention that it is a part charge sheet?
Lordship may kindly see page 13, column 1, the court of honorable CJM, then fourth, number 2, final report, part charge sheet. Part charge sheet is mentioned, Lordship, on 31/10. Next 6 number also, dear Lordship. If charge sheet part. I'm the sole accused person, Lordship. I'm thoroughly interrogated. Investigation has been done.
Now at what stage it is trending?
Investigation stage, Lordship, part charge sheet has been submitted, Lordship.
No, after submission of charge sheet,
Lordship.
you are produced regularly before the that court?
Yes, Lordship, I am produced.
And whether copies of
No,
under
n-
207
nothing,
has
sir.
been furnished?
No, Lordship. Not yet, sir.
How will we verify? We will call for a status report.
Lordship, may kindly say the IOC's part submit.
No, but
meaning thereby-
merely on the photocopy of that charge sheet, we have to peruse other materials also.
Lordship,
At what stage, whether the trial is proceeding or not.
Lordship, if Lordship is on there, my learned friend may be asked to take instruction over telephone, Lordship. Lordship may kindly take up the matter after some time. Because 122 days.
No, but you have approached this court after 120.
Yes, Lordship.
Therefore, you have to wait.
Yes, Lordship. Lordship,
Heard Mr. G.
M.I. Hussain.
M.I. Hussain, learned counsel for the petitioner. Also heard Mr.
Lordship, Supreme Court decision is there that
No,
cannot.
we
go
have to
long.
verify whether merely mentioning part charge sheet, at what stage trial is pending, whether trial is proceeding or not, because you are not able to inform this court.
Lordship, may kindly ask my learned friend to take instruction over telephone to that effect, Lordship.
No, what is the urgency? Because they,
Because I mean, custody Lordship, Lordship knows for 122 days.
heard
Right.
Mr. M.I. Hussain, learned counsel for the petitioner, also heard Mr. K.K. Das, learned additional public prosecutor. This application has been filed by the petitioner under section 439 of the Code of Criminal Procedure. Who has been detained behind the bar since last 122 days in connection with Manipur PS case number 161/2023. Learned counsel for the petitioner has submitted that in the instant case, the charge sheet has been laid against the present petitioner in part, and to substantiate his submission, he has referred to column number 5 of the charge sheet, wherein it is mentioned as P within inverted comma PART. However, learned counsel for the petitioner is not able to inform this court as to at what stage the trial is pending. Hence, up-to-date status report of the case pending against the present petitioner would be necessary for consideration of the instant bail application. Hence, call for an up-to-date. What is the sessions PRC case number or?
That is not yet done, Lordship. Therefore, I am submitting that
No,
no progress to that effect, Lordship.
you are not able to inform this court. What is the PRC case number? What is the session?
That case number is not yet there, Lordship.
Okay, we'll let the. So it is still pending at the investigation stage.
Lordship.
You take information.
Lordship may kindly say one order I do have of the honorable.
When
court.
charge sheet has been filed, you,
Charge sheet filed on 31/10, Lordship.
in which case charge sheet has been filed? After filing of the charge sheet, no PRC case has been registered.
No, Lordship. Lordship may kindly say the honorable. court order. Which one?
Yes, it is. Try to send it. Try to send it, yes.
It is the more yes.
No, there is a PRC case number which is not mentioned here in this order sheet. Let a status report be called for from the Court of Learned Chief Judicial Magistrate Bongaigaon as regards the status of Manikpur PS case number 161/2023. Who will call for the status report?
So it will be, if the court then
registry shall-
registry lodge.
Registry shall send requisition for the said status report from the Court of Learned Chief Judicial Magistrate, Bongaigaon, which should reach this court by 19th of January,
Maybe on 18 Lordship.
18th January. List this case accordingly.
Oblige Lordship.
May I please, your lordship, but 306 is the allegation manner. 33 days behind the bar, my lord. Registered or case bearing able to outcome.
Heard Mr.
Yes, Rana.
S. Rana, Learned Counsel for the petitioner, also heard Mr. K.K. Das. Let the case diary be called for fixing.
23rd.
23rd one for case diary.
Oblige.
May I please, your lordship. Lordship, this is the stated case, my lord, and petitioner is behind the bar for last 124 days. My lord. Lordship will find the FIR at page 10, my lord. There are two FIR named accused persons, my lord. One is Subhash Sutradhar, another is Pradeep Sutradhar. My lord, one of the accused my lord has granted 3 years bail by the court, my lord. And other family members also granted 3 years bail by this on the court, my lord. I have annexed all the orders, my lord. As because this petitioner has been arrested during the pendency of this case, his anticipatory bail was not granted, my lord.
Why your prayer is rejected? Where is the rejection order?
My lord, as because this is case of lordship, that is as page 31, my lord. As because this is a case of 302, my lord, my prayer by the learned court below after filing certificate was not considered, my lord.
Heard Mr. B. Chanda, Learned Counsel for the petitioner. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Ajit Sutradhar, who has been detained behind the bars since 10/9/2023, within bracket for last 124 days,
My lord.
in connection with Hojai PS case number 377/2023, corresponding to PRC case number 1256/2023. Learned Counsel for the petitioner has submitted that in the instant case, the charge sheet has been laid against how many petition
My lord, 3 against 3, my lord.
against 3 accused persons, including the present petitioner, under section 143/302 of the Indian Penal Code. It is further submitted that the other 2 accused persons, namely
My lord, that is Subhash Sutradhar, my lord.
Subhash Sutradhar,
My lord, was granted bail, my lord. Lordship will find that page 36, my lord.
Subhash Sutradhar
And my lord, other family members, that is page 33, my lord. Election
against how many persons charge sheet has been laid?
charge sheet has been filed, my lord. There are 3 persons against 3 persons, 143 and against 3 persons, 143. 320.
No, my query is against total how many persons charge sheet has been?
Total, my lord, that is 6 and 9 persons. my lord.
Instead of 3, right, 9. Against 9 persons charge sheet has been laid. And out of 9 accused persons, how many are on bail?
My lord, that is all other family members, 1, 2, 8, 7, 6, my lord.
5 persons are on.
5,
bail.
5, 5.
You are not clear with facts.
My lord, 5, my lord.
5 persons are on bail.
Hello.
The prayer for the prayer for bail of the present petitioner was rejected by Learned Committal Court by the order dated 21/12/2023
Lordship,
as the case is exclusively tribal by the Court of Sessions.
my lord.
And one of the section in under which charge sheet has been laid is also 302 of the Indian Penal Code. Additional public prosecutor. Since co-accused have already been granted bail in this case, and since the present petitioner has been detained behind the bars for last 124 days, and investigation has already been completed and charge sheet has been laid, his further custodial detention may not be necessary if he
My only objection is that only, Lordship, in page number 14, my lord. There the witnesses also named, my lordship, his involvement, that
and an additional public prosecutor objects the grant of bail to the present petitioner, considering the incriminating material against the present petitioner. Officer, what was the last line? Yes. If he otherwise cooperates in the trial, hence the above named petitioner is hereby allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of learned SDJM Hojai, Shankar Devna, SDJM M Hojai. With above observation, this bail application is hereby disposed of.
May play lordship. Like the 439 application lordships. April is 16 lordships. You also earlier rejected this bail payer lordships and now petition
Earlier rejected,
lordships, second application lordships.
it is charge sheeted case
No,
or
no, lordship.
case diary would be required.
Kindly give a short that because my lord.
Heard Mr. M. Hawk,
Lordship.
learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary,
23rd.
fixing
My
23rd,
lord, 23rd, mandatory part will overall lordships, 118 lordships,
when mandatory period will be.
123rd lordships.
So let it be on 23rd.
Well, on 18 lordships or 19 lordships.
But many cases are fixed, Lordship, I am mistaken.
On 19 lordships.
18, 19, we are
Many cases-
overburdened. Your case would, even if it get listed, it may not reach.
19 lots or 21 lordships.
22nd of 22nd did you?
Let it be on 22nd.
Middle also 439. And my lord,
Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. J.M. Hussain.
Sulaiman,
J.M. Sulaiman. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary,
23rd, Lord.
fixing 23rd.
from the third,
That case also we can-
obliged.
May I please your lordship? He's behind bar for 27 days, your lordship, as on today. The FI is at page,
307 is there.
may I read the FIR, your lordship? Page number 9, your lordship.
We are fixing a short date for
Yes, your lordship.
case diary.
Your lordship, there is no ingredient of section 307, your lordship. Only to make out the case, at least 307 has been.
Your prayer was rejected by lower court
Yes, your lordship.
after perusal of the case diary. Where is the rejection order?
Rejection of the case. Rejection of the case.
No, your lordship.
There is no rejection order.
No, your lordship. There is no rejection order, your lordship.
Lordship, in
Your
the-
lordship,
Lordship, if I
may
look
read
into
the
the.
FIR. May I read the FIR, lordship?
No. Don't you think that we have to go through the case diary? Or you have a very strong case, even without case diary? If you have some
Because your lordship is a clear case of section 279, your lordship. This is a rash and negligent driving, your lordship. There is no ingredient of section 307, your lordship. And neither there is any criminal conspiracy, your lordship. From the FI, it is clearly, it can be clearly transpired, your lordship.
In the last line, my lordship, as per my knowledge, the incident was because of old enmity, lordship.
So whether there is any intentional hitting from behind or it was an accidental hitting,
That line,
case diary would be required.
that line, your lordship, in the vernacular, your lordship, if looked into page 13, your lordship, that line has been entered later on, your lordship.
No, therefore we have
There-
to peruse the,
There is no such enmity, your lordship.
therefore we have to peruse the case diary. Heard Miss
As Nazneen.
S. Nazneen, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary, hence call for the case diary.
24th, lordship.
On 19, your lordship.
Too many cases, lordship.
Fix a shorter date.
Lordship, 23rd,
20, your lordship.
20 is holiday, lordship.
20.
20 holiday. 25,
23rd,
25.
23rd January for wisdom.
Yeah, please. My lord, in this case, perusal of the case diary would be necessary, my lord, because the section is 304B.
Okay, heard Mr. A.
Yeah.
Ali, learned counsel for the petitioner, also heard Mr. K.K. Das, call for the case diary
Along with the medical report.
along with
Postmortem
the,
report.
along with the postmortem report, fixing
23rd.
23rd.
23rd January for case diary.
Obliged.
May it please your lordship. Lordship, the petitioner herein is implicated on the section 468, 71 and 409. Your lordship, what happened, your lordship, on the same subject, your lordship, an FIR was lodged on 9/12/2023, your lordship. That FIR is on page 18 to 22, your lordship, the translated copy. Your lordship, thereafter, your lordship, he got arrested, your lordship, and thereafter he obtained an order of bail from the learned court of JMFC North Salmar, Abhayapuri. Before he was released, your lordship, another FIR was filed, your lordship, though by a different person, but on the same subject, your lordship. And again, he was arrested and he couldn't come out of jail, your lordship. Your lordship, that FIR is on page 11, your lordship. So that is the may I read out the impugned FIR, your lordship? Translated copy, your lordship, starts from page 11. Sir,
Same subject matter.
your lordship, regarding that plot of land, it has been, your lordship, forced and it has been mutated in the name of the petitioner. That is
Same plot of land.
same plot of land, your lordship. Same plot of land, your lordship.
Since when you are in jail?
21/12/2023, because I was arrested on the basis of the first FIR that was lodged on 9/12/2021, or 23. Thereafter, this FIR was lodged. The moment I was granted bail on 21/12/2023.
Why your bail prayer was rejected by the court below?
So, lordship,
Against this arrest,
Yes, sir.
you have moved the,
I don't have that instruction, your lordship.
that is necessary. That if it is rejected after perusal of the case diary,
Your lordship, a bare perusal of both the FIR, your lordship, indicates that the subject matter is same. And my
no,
humble-
that have you moved any application before any other court? You don't know.
Your lordship,
that-
your lordship, I have not been provided, so my general.
No, that instruction is necessary because on what ground your earlier prayer was rejected, that is relevant while considering.
Your
We
lordship,
will be calling case diary, fixing a short date.
but your lordship's, implicating one person on the same subject matter, your lordship, amounts to double jeopardy.
Where is the first FIR?
Your lordship, first FIR, your lordship will find on page 18, your lordship. The translated copy. Your lordship, I'm known as Koribhanu Nasu, wife of so and so. It's a long FIR, your lordship. I'm the owner and possessor of the plot of land measuring. I have learned that one Koribhanu Nasu, Nessa, daughter of Paratri, your lordship. Koribhanu Nasu, daughter of so and so, resident of so and so, has transferred illegally by putting thumb impression in the registered sale deed by so and so, impersonating herself as Koribhanu Nessa of my aforesaid plot of land measuring 5 bigha, which is covered by so and so tag number, in favor of one Anwar Hussain. So this is the petitioner, your lordship. So now, your lordship, this Koribhanu is been alleged by Koribhanu. Now, after this FIR is filed, this Koribhanu also filed an FIR that I am not the person, Anwar Daily. Second 19. So this FIR is filed by one Koribhanu, alleging that one Koribhanu impersonated her as Koribhanu. Now, after this FIR has been filed, since Koribhanu fell in trouble, your lordship, she again filed an FIR.
Where is the second FIR?
Second FIR, your lordship, will find from page 11. Page 50, yes, your lordship.
Page?
Page 11, your lordship. Translated copy, your lordship.
Yes, read the.
It is respectfully submitted that about 2 years ago, the above name accused number 1 induced me to sell my landed property and took my voter ID card, Aadhaar card, and thereafter took joint photo of myself with him in my landed property. At present, I came to learn that the accused number 1 in connivance with the accused number 2 has forged my document without my knowledge and sent my name from Koribhanu Nessa to Koribhanu Nessa, and thereafter mutated my landed property in his name, being land measuring so and so by showing.
What is the dag number, pata number?
Yes, sir. Here, dag number is 18, patta number 29.
And in the earlier case?
In the earlier case, your lordship, the dag number 18, patta number 29.
Sale deed number?
Sale deed, register, permission by NOC 13. Your lordship, permission was taken up, permission was obtained, your lordship. Sale permission was obtained. So now this, since Koribhanu Nessa was implicated in the first FIR, she again filed an FIR in the second instance, your lordship.
We have to peruse the case diary. Yes, Mr. Das.
Lordship, the similar kind of PS case is same, Lordship. Item number 5. It was fixed on 23-1.
Same.
Same, FIR is same.
Okay, we have already called for the case diary.
23-1, 24.
Heard Mr. I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Das, additional public prosecutor. Considering the nature of allegations level in the affair, perusal of the case diary would be necessary. Since case diary has already been called in connection with a similar case concerning the same police station case number on 23-1, let the case diary be called for fixing 23-1. Let this matter be listed along with case, which was the
142 bail.
along with bail application number 142 on 23-1.
Item 60 from Subject Secretary.
Late lodge. Well, at 439 applications, well, the petitioner is behind the bar since 10/12/2023. And is a renowned businessman of Mumbai. I'll show how this FIR, your lordship, I'll straightway go to the FIR, which your lordship will
No,
find.
before that, whether perusal of the case diary would be necessary.
That's what I have, how, there's a misuse of law as well as power also, I'll show, that where the case has to be registered and what is the transaction is about, and whether this, my custodial detention is necessary or not, and whether this section which has been applied here, is attracted to me or not. That's your lordship has to see,
Okay.
Now,
where is the FIR?
FIR at page 55, my lord. You start from 55, my lord. And your lordship may kindly straightway go to page 57, my lord. Page 57, my lord, your lordship got it.
Yes.
Well, on 22/9/2023, at around 9 p.m., the complainant Amit Tipnis, aged about 48 years, son of so-and-so of A401 Rawal Tower Sector 11 CBD, Belpur, Navi Mumbai, your lordship. Kindly take note of these addresses, my lord. Addresses of the petitioner as well as the complainant, my lord. Lodged an FIR at this PS that once Sachin Adhikari, the petitioner herein, who is the holding the
Where this FIR was lodged?
here in Tahsil Ambari, my lord,
Okay.
in Assam, my lord. The entire transaction was in Mumbai, my lord.
No, read, please.
My lord, yes, my lord. The Sachin Adhikari, who is holding the post of CEO at the point in a company name called Breed Approach, the complainant to join them. So he resigned from his former job and joined under the guidance and assurance the Sachin Adhikari and his wife, Tejaswini Adhikari, in order to give him a share from his profit. Kindly note that he has promised to give the share of the profit of the company, my lord. Now, then in 2011, Sachin Adhikari resigned from the post and worked employment in Monavi, a company at USA, until 2014. During that, the complainant had grown phenomenally in the company and was the best a performer, was offered take up as a director of the state company. But despite of not being a part of Breed, the two accused remain control over Breeds. Also, the Adhikaris and Sasikant Tagre.
What is this Breed?
Breed is a company, my lord. It's a skill company, my lord.
Okay.
I'll come later on, my lord.
Okay.
Adhikari and continue the active part in mastermind of the financial affairs of the company. That is, Breed existed from India in 2015. The accused person incorporated BMW Global, and by 2016, the whole undertaking business growth, trademark, and brand name Breed was transferred to BMW Global, my lord. At that relevant point of time, the accused person set up the office at ward number 15 of Bhaskar Jyoti Nagar, Guwahati, GST number so-and-so. For the purpose of takeover, the accused approached the complainant, and he was promised to both would be equal in the business share of 50% ownership share of BMW and make him one of the two directors. The complainant later learned that the transferring fund from BMW, they used to sell companies, farm Sachin Adhikari and Tejaswini Adhikari by creating an agreement dated 16 March 2016, where it is showed that the BMW is the client of the Global Vistas Enterprise, and on behalf of BMW, document is signed by Mr. Vaibhav Kulkarni and Mithali Patne from Global Vista, but both these persons have no authority from the board of directors, and to the utter surprise of him, various employees were also involved in the scam, and the Adhikari also made the partners director, proprietor, and said shell entities. After the balance sheet and the financial statement of the BMW got audited since 2007 to 2021, the accused person has transferred directly from the said company over 139. But the complainant, my lord, your lordship, last line, your lordship, kindly see, but the complainant only the salary has never received the dividends and profit of the said company. In nutshell, my lord, what is the grievance is this? The company is a private limited company, assuming this true, my lord. What has happened? Entire transaction was in Mumbai. And what is his grievance? That he got a salary, he being one of the part of this company, he get only the salary except dividend and profit. So this is basically, is a nutshell, his grievance, on the basis of which, my lord, the entire case is set in motion, my lord. Now, whether, my lord, your lordship will kindly see, I am behind the bar since the police has gone to Mumbai, my lord, and took me from there, and I am here, my lord. languish in the judicial custody, my lord.
No, this company is, the gist is that original company was floated at Mumbai.
Yes, my lord.
Thereafter,
Only, my lord, what has happened, it had, for the purpose of
what is this BMW Global?
it should be BWW, my lord. BWW, my lord.
But
It is a company floated by the complainant, my lord, and other directors, my lord, and the shareholders, my lord. So basically, my lord, what his grievance is this, my lord, that he didn't get his salary, except the salary, he didn't get dividend as well as the profit of the company. And he said that the siphoning of 139 crores, my lord, to share companies. Now, it's a private company, my lord. My lord, the transaction, suppose, if your lordship take the FIR on a face value, my lord, it's a transaction, business transaction, suppose it's a dispute between myself and the complainant, my lord, it's a civil dispute, my lord. And all this are part of the documentary evidence, my lord. Whether my custodial detention is necessary and whether the question of 409, my lord, where is the entrustment, my lord? There has to be entrustment, my lord. Before misappropriation, 409. That is the first, that has to be fulfilled. my lord.
under what provision it has been registered?
My lord, your lordship, kindly see 120B, 406, my lord, 409, 419,
The
420.
allegation of forgery is also there.
Yes, my lord. What is the question of forgery? Where, my lord? Mere reading of this FIR, my lord, whether any forgery comes out, my lord. Any ingredients, my lord. Kindly see that said that so-and-so he was the director of so-and-so, that the company has been floated, then the company was shifted to BWDD, my lord.
You tell me the gist of FIR in,
What the gist of the FIR is this, my lord. The complainant, the gist of the FIR is this, my lord. There's a company called Brit.
who is Satish Sahu? No, not Satish Sahu. Who is the first informant?
The informant is, my lord,
Sachin Adhikari. No.
Amit Dipnis, my lord. He's referred his name, my lord.
Yes, what Amit Tipnis says in FIR.
No, he said this is the FIR, my lord. What I have read just
Yes,
now,
you
my
have
lord.
read it is a long FIR. What is the gist? I want to know.
Gist is this, that they are also part and parcel of the companies. Of Brit, thereafter.
Amit Tipnis is one of the directors.
Director, my lord. And what?
And you are also one.
No, I was the Brit there. Thereafter, I resigned, my lord. Thereafter, I resigned. And there's another parent company has been there. What his grievance suggests?
Now, what is this BMW Global?
BWD, my lord.
The mention is BMW Global in the FIR.
Well, that has been created by the complainant and other shareholders, my lord.
Okay.
And after the Brit was been closed, my lord.
The original company was Brit.
Brit, my lord.
Okay.
Brit. Thereafter, BWD was formed by the complainant. He was the director there, my lord. 50% shares holder, my lord. What he
The
says
first
that
informant
even the Brit has been closed.
No,
also.
let me understand.
My lord.
The first informant was one of the original director of Brit.
No, he was not. He was 12 whole time. This thing. Then, my lord. Then it has been the BWD.
No, I am not getting you.
My lord, in the Brit, my lord, he was incorporated as a shareholder and also director also. Well, thereafter, my lord, that
Whether he was a director or a shareholder or
he's a director.
the Tipnis was a director.
Director.
And who was in what capacity the accused were involved with that company? Adhikaris?
And I
Yes.
am the advisor in BWW company.
No,
After I exited from Brit.
No, what was your relation with the Brit company?
Earlier I was in the Brit, my lord.
As
And the director, my lord.
yes, that is my query.
Yes, my lord.
You were one of the directors.
Director, my lord.
The informant was also one of the,
Director.
both of you were directors.
2012, my lord.
Thereafter,
My lord, Brit is closed, my lord. Then BWD has been formed.
BWW. But there is no mention of BWW in the.
They have
FIR.
mentioned as a BMW, my lord,
No, now we are concerned first with the FIR. Let us
Yes.
understand the FIR.
FIR, my lord. My lord, your lordship will kindly see, then forwarding report, my lord. In the forwarding, it has been
Now,
corrected.
before we
No,
go
no,
to.
yes,
for-
my lord. Name, my lord,
allegation is-
name has been corrected in the, my lord, forwarding report, my lord. Name has been corrected. Page 60, my lord. The forwarding report, my lord. In the forwarding report, your lordship will, well, if we go through the forwarding report, you'll get to know that
No,
what.
the FIR says that you incorporated BMW Global.
Yes, it said that BW, actually it should be BWD.
No. Make your clarification later on,
Well-
but let us read the plain reading of the FIR says that you incorporated BMW Global
My lord.
and then transferred 50% of ownership of,
Well, that is not correct, my lord. What it said is not correct.
may not be correct,
Well,
but
correct,
I
but
want to
assuming-
know the allegations. What are
It's
the
allegation, my lord. The allegation said that incorporated and he became the 50% of that.
Who, the petitioner,
No, my lord, that.
the
as per
informant,
Complainant, my lord. The Tipnees, my lord.
and thereafter Sachin Adhikari and Tejaswini Adhikari by creating an agreement.
The bill.
And what is there in Guwahati? How
Well, they
Guwahati
have
link?
a GST compliance office, my lord. He has along with the two employees, my lord, a GST compliance office. My lord. So that's how, my lord, they have, instead of going to Mumbai, my lord, they preferred to be filed here, my lord. Reason based known to the complainant and, my lord, the state, my lord.
Okay, proceed.
Then, my lord, your lordship will, in nutshell, my lord, your lordship will get to know that what the grievance is this. He has given a story that how this company has been formed and what is his share, how and what his grievance is this, that he accept the salary, he did not get the dividend. Last line, your lordship is clearly, but the complainant received only, my lord. Last line, my lord.
Okay.
The entire, the things comes in the last line only, my lord. The complainant received only the salary and has never received dividend and or profit of the said company, my lord. So that is the only grievance. So the FIR, this FIR is concerned, my lord. Now, if your lordship will kindly see that only the grievance is that he didn't get accept the salary, he gets only the he didn't get the salary of dividend as well as the shares of the profit. Now, my respectful submission is this: whether is it my lord, the criminal law, my lord, has put on me, my lord, for not getting a salary and shares of profits. And my lord, your lordship will kindly see the forwarding report now. It is on 10th, the forwarding report, which your lordship I annexed, my lord, at page 60, my lord.
Listen. Yes,
Now, your lordship kindly see the forwarding report. my lord. May I read the forwarding report? my
yes,
lord?
at page,
Page 60, my lord, start from page C. Annex as 3, my lord.
yes.
Now, I have been brought from Mumbai, my lord, and I have been Mumbai, I was picked up from. And I have been shown arrested, my lord, at Guwahati, my lord, on 10th, my lord, and I have been proceeded there, my lord, with a prayer for, my lord, custody, their custody, my lord. Now, kindly see the brief of the case, that on 22/9/2023 at 9 p.m., the complainant Amit Tipnees, aged about so-and-so, resident of so-and-so, 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 lodge an FIR at PS that once Sachin Adhikari, the petitioner who is holding the post of CEO at the point in a company named Breed, approached the complainant to join them. So he resigned from this former job and joined and under guidance and assurance, Sachin Adhikari and his wife Tejaswini Adhikari, in order to give him share from the profits. So then in 2011, Sachin Adhikari resigned from the post and worked in the employment of Mona Valley, a company at USA, until 2014. During that, complainant had grown phenomenally and company and was best performer and was offered to take as a director of the said company. But despite not being a part of Breed, the two accused remained control over the breeds. Also, Adhikaris and Srikant Tagre continue to be active part and mastermind of her financial affairs of the company. The Breed exited from India in 2015. The accused person incorporated, whether you currently see BWD, what it said BMW, let's be clarified as a BWD Global, and by 2016, the whole undertaking business growth trademark, brand name trademark, and brand name Breed was transferred to BWD Global at the relevant point of time. The accused person set up an office at ward number 15, Bhaskar Nagar, Jyotipath, so-and-so, for the purpose of takeover. At the said accused approached the complainant, and he was promised that both would be equal in the business of a share, that is 50% ownership shares of the BWD, and made him one of the two directors. The complainant later learned that the transfer of the funds of BWD, but they used to sell company's firm of Sachin Adhikari and Tejaswini Adhikari by creating an agreement dated 16 March 2016, where it is showed that BWD is the client of Global Vista Enterprises, and on behalf of BWD, documents is signed by Vaibhav Kulkarni, DMA, and Mithali Patne from Global Vistas. But both these patrons have no authority from the board of directors. And to the utter surprise of him, the various employees were also involved in the scam. And the Adhikaris also made them partners, directors, proprietor of the shell entities. After the balance sheet and financial statements of BWD got audited since 2007 till 2021, the accused person has transferred directly from said companies over 139 crores, but the complainant received only the salary, has never been received dividend and the profit of the said company. Hence this case, my lord. And the ground of arrest, if your lordship will kindly see what are the grounds, my lord.
Yes.
The arrested Adhikari is the prime accused of the case under section so-and-so, 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 and other offences under various acts such as PMLA, complainant, etc. During investigation, it is found the accused have indulged in systematic cyberning of and laundering of money stolen from Breed Worldwide Private Limited and BWW Global Private Limited, collectively called BWW. The money siphoned from BWW has been routed to more than 9 shell companies, firms of Sachin Tejaswini Adhikari, such as so-and-so, 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 so-and-so. These are 9. These involves voluminous colorable transaction and forging and fabricating voluminous documents for transferring huge amounts funds from BWD to Global Vistas Enterprises and other shell companies to the tune of rupees 139 crores. During the investigation, the accused person is not cooperating and giving a evasive answer. During the investigation, sufficient evidence have been found against the arrested person. Under the circumstances, the accused person was arrested and produced before your honor to court with a prayer to allow the 10 days police custody under the following grounds. These are the grounds which have been cited, my lord. Now, my lord, if your lordship kindly see the forwarding reports and the FIR, my lord. My lord, whether any offences under section 409, my lord, attracted, my lord, my respect is no, my lord. Number one, the question of, first of all, there has to be a question of entrustment. And where is the question of sitting, my lord? But I am not on assuming, my lord, true, my lord, whether my custodial detention at this stage is necessary or not, my lord, that your lordship has to look into. Secondly, my lord, I am presently at Guwahati Medicals having a problem on the heart, my lord. And there I have been, my lord, admitted in Guwahati Medical College.
You are not in custody.
No, I am in the custody, my lord. I am
By
a-
the order of the court, you are in.
Yes, my lord. I got a massive cardiac arrest, my lord. So I have been shifted to the GMC, my lord.
Yes.
So my respectful submission, my lord, your lordship will kindly see that whether, my lord, whether this section, number one is, my lord, absolutely, my lord, power which has been exercised, my lord. My lord, while, my lord, registering case in here, the entire transaction, my lord, is in Bombay. And only because that there is a GST office and he has come and has been brought from there, that is number one. Absolutely, it is illegal and beyond the jurisdictions, my lord. That is number one. Number two, my lord, is the prima facie, if your lordship kindly see also that,
Not GST office, because your BWD Global is situated at Guwahati,
no,
to
it is-
which you have transferred the.
no, not Guwahati, my lord. It's a GST office, GST, my lord, for compliance of the GST, my lord. It's stated for compliance of the GST, my lord.
But you have set up an office of BWD Global at ward number 15, Bhaskar Nagar.
Because they have
For whatsoever purpose, you have an office.
my lord, if your lordship.
The
kindly-
allegation is that to BWW, you have transferred the business of the Brit.
My lord, no, yes, my lord, BWDD, my lord, BWW, my lord, has, my lord, GST, my lord, the office here for compliance of the GST.
No, because
My lord,
because
the
your-
companies, my lord, if your lordship kindly see, it's a GST compliances office is there. So
It is
all the
not
money,
because-
assuming all this money has
no,
been.
I want to understand.
My lord,
It is not because GST office and therefore cases. It is because your branch is in Bhaskar Nagar, therefore you have to pay GST here.
no, it has not, no. My lord, if your lordship kindly see what is said.
I'm
Uh,
okay.
Oh.
Now what is your submission?
My lord,
Because there are, what I understand, there are allegations that you have opened shell companies, transferred amount to those shell companies, you have fabricated certain, these are the
this
allegations.
is the allegation.
Allegation.
Allegations, my lord.
Now, to
That will-
verify
that will-
those
that will- that will
allegations.
Come when trial start, my lord. If they found, if
No,
they
but
found,
now to to ascertain whether your custodial detention.
this is necessary or
excessive
not, my lord. That is has to be.
Whether we have to peruse the case diary. Case diary is there.
No, my lord. My lord, here, my lord, what happens? First of all, the petition which was filed by the petitioners, my lord, he is the main culprit and the main person. There are 9 numbers of accused, my lord.
In
Here,
this
my
case,
lord,
in this case.
In this case, 9 numbers of accused, he is the main persons. And moreover, my lord, the FIR which was annexed, my lord, it is not the FIR, my lord, it is the form, only first part. The entire FIR is, my lord, there are 35 numbers of paragraphs, my lord, 42 annexures is there. The complete FIR is not annexed in this case, my lord. The only format of the FIR, the first page is the form, which is only annexed, my lord. That's why, my lord, your lordship has not
Oh,
clarified
yes.
everything, my lord. And moreover, my lord, 3 of the accused.
It
my
is
lord,
the format only.
Yes.
Where is the
main FIR is not there,
main
my lord.
FIR is not there on.
Yes, I apologize for that. We just saw it. There was a mistake. It is not 5. There are 19 pages of it. Only the first format has been filed.
Therefore, I was
Clarity.
not understanding.
Yes, lordship.
Neither you are able to make it clear.
No, your lordship will find now, I got it, my lord.
Okay, let Mr. Fukun
My
complete.
lord. Thereafter, I have to show, my lord, there are out of 9, my lord, 3 numbers of accused has filed an anticipatory bail application before the court number 15, my lord. It was listed before the court number 15. And the out of which, my lord, 1 is the present petitioner's wife. Her bail application was rejected after perusing the case diary. And other 2 is the daughter of the present petitioner's, my lord. Their bail application was allowed because there is less, my lord, the incriminating materials against those 2 daughters, my lord, and they are studying at abroad. That's why, my lord, their bail was considered. But the wife the present petitioner's wife, my lord, her bail, antecedent bail application was rejected. And in this regard, my lord, you're subject to your lawsuit corrections, have to place one judgment before your lawsuits. Yeah, paragraph 3, 4, and 5, your lawsuit make queries. Lawsuit, this is your lawsuit subject to your lawsuit corrections. This is recent judgment which is passed on 12 December 2023, my lord. In view of the grant of a permissions to withdraw the special leave petition, we do not think it is necessary to delve into the matter any further. However, we have to retreat it to concern of this court on the lethargy in the following the earlier order in the matter of dealing with a bail application arising out the same effort to avoid conflicting decisions. We shall not be understood to have to say that all circumstances co-accused in such a case are invariably entitled to parity, and that such entitlement is certainly depend on a various relevant fact and factors. A 3 judges bench of the court so-and-so as per the order dated so-and-so took a note of such situation and observed as follows. We have come across a various matter from the High Court of Allahabad wherein the matters arising out the same FIR are placed before different judges. This leads to anomalous situations inasmuch as some of the learned judges granted bail and some judges other refused the grant of bail, even when the role attributed to the applicant is almost similar. We find that it will be appropriate that all the matters pertaining to the FIR are listed before the same judge so that there is a consistency in the order passed. After making such observation, this court issued a direction to the Registrar of Judicial to communicate the said order to Registrar Judicial of the High Court of Allahabad. So lordships, here in this case, what happened?
Other matters are pending.
My lord, yes, that is pending before the court number 15. My lord, there was also my lord, same jurisdiction case. My lord, issue was raised. My lord, that was discussed. We argued. My lord. So let it, my lord. I leave it to lordship after this judgment.
My lord, what my lord, give a reply to my learned friend. My lord, what my instruction is this: the matters, what the my learned friend has cited, the judgment, my lord, is regarding parity, my lord. That all the bail application, that is a bail application under 438, my lord. It's a 439, my lord. It's a regular bail. That's an anticipatory bail. And that have all been disposed of, my lord.
No,
FIR is not different, my lord. Subject issue is same.
Maybe same.
these are pending or disposed of.
Pending, my lord. No.
Disposed of that.
Oh, yes. Oh, yes, disposed of.
Disposed of.
Disposed of.
It's a disposed of. And lordship, I'll show one thing also, my lord. What my learned friend has submitted just now, my lord, he did not receive the case, the lordship. Kindly see the board, my lord, where it has been stated that diary is there. And now it has been removed, my lord. I don't know, my lord, how it's been removed. It has been shown, my lord.
My lord, today is the motion stage. How can I call the case diary, my lord, without having the court order, my lord, call the case diary, my lord?
When PP is there,
Yes,
why
my
are you looking at board?
No, that what, because we have to see that.
My learned friend, very wrongly, my lord, they have said that. It's
Now,
wrong. Today is the motion stage.
This is the instruction of the public prosecutor, my lord.
Yes,
We
what
believe
is your
in the public
submission? What is your
prosecutor, not that we are not
submission?
disbelieving.
My lord,
No, we are ignoring that. The earlier anticipatory bail applications are not pending or pending. That factual situation you have to.
my lord, yes, I have the order, my lord, that is disposed of, my lord. These are the, my lord, court orders.
If those are disposed of, then this has no applicability.
My lord, that's why I was subject to your lordship correction. I leave it to your lordship. That's why initially I have made these submissions, my lord.
Okay.
Because it's my duty to, my lord, point out the said judgment of before.
Then there is no bar in this court taking up this matter
My lord,
because
I leave it to your lordship, my lord. in this
the
regard.
Supreme Court said that at same point of time, different courts should not deal with same FIR case, bail matter pertaining to same FIR. As there may be conflict of.
Yes, my lord, this type of case is going on till today, my lord. Our registrar did not take any initiative. Today, my lord, same case, case has been listed before the court number 15, court number 24.
Today.
Yes, today also, tomorrow also, yesterday also, every day is going on, my lord. Every day we are facing, my lord.
Okay.
Different court, different order, my lord, same PS case, my lord.
No, if you make a clear submission, then I can.
Yes,
give-
we are facing, my lord. Yesterday also, my lord, so many cases.
Not regarding to this case, no. The different cases.
Yesterday only, my lord, the land grabbing cases.
No,
Some
no,
cases are.
I'm not on that general situation. I'm regarding specific to this case.
My lord.
Whether presently any case is
No, my lord.
pending.
No.
Presently no
My lord.
case is pending.
Three cases has been filed, that has been disposed.
Then there is no bar.
My lord.
Then because earlier cases are disposed of cases
My lord.
and earlier cases were not by the present petitioner.
Well,
So I think there is no bar. Then the question of case diary, I think case diary would be required.
My lord, yes, correct. This is very serious offense, 139 crores of scams.
Mr. Bora,
this-
case diary,
my lord, yeah, His Lordship may call for the case diary, my lord. My lord, your lordship, that is why, my lord, your lordship, to see that whether my customary retention is necessary or not.
Yes, after paring the case, there your lordship may
heard
consider
Mr.
it.
Heard Mr.
My lord,
Your lordship's permission. The three anticipatory bails are actually listed in your court, but unfortunately, your lordship was not well the other day. We had to therefore mention it because there was a protection granted to us under the anticipatory transit bill in Mumbai. So the protection was expiring on the 8th. Your lordship was not available on the second half. So we had to mention before the learned acting chief justice and then post it before Rubin Foucault because he had already heard it on the first occasion. The first
Okay,
day.
but now those cases
They
are
have all been
disposed
disposed of, your
of.
lordships. Two have been
So
granted bail.
that bar is not
Yes,
applicable.
I wanted to point it out that only that this initially was listed before your lordships only on that
Okay,
particular day.
We are
And I
calling,
apologize for the FIR. If your lordships gives me a permission, I'll file
Yeah.
it, but it shouldn't be transpired that I have filed it unintentionally. There is
no,
something
but
happened.
that copy of FIR would be required.
I
My
will,
lord,
necessary.
definitely,
You
we-
my
may,
apologies straight away.
My lord,
you may file an additional
additional
affidavit.
affidavit. We'll file a.
I'll be extremely grateful.
Heard Mr. P. Bora, learned senior counsel assisted by Mr.
R. Fukon, my lord.
R. Fukun, learned
R.B. Fukun.
counsel for the petitioner. Also heard Mr. M. Fukun, learned public prosecutor, Assam. Considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary. Hence call for the case diary.
My-
Fixing
My lord,
when
Mumbai, law, Mumbai, next to the.
January. On 24th, my lord, 23rd of bonus.
fixing 24-1 for case diary.
My,
Learned counsel for
Can
the,
it be on 22nd, it is Potasi only. My
22nd.
fixing 22nd one for case diary.
My lord.
Learned counsel for the petitioner has also prayed for allowing them to file an additional affidavit to bring on record the the original, the copy of FIR,
My lord.
the prayer is allowed.
I'm
The-
extremely
And my lord, my learned friend is appearing for informant, my lord, senior friend.
Also, you have any submissions?
No.
Also, heard Mr. A. M. Bora, learned senior counsel, assisted by Ms. C. Chaudhary, appearing for the informant. Let this matter be listed accordingly on
March of,
22nd. February.
March of.
Lordship. Petitioner was shown arrested, my lord. In connection with the courts of PS case number 324, my lord. FIR is, my lord, page number 15. 13, my lord.
Mr. Das, whether diary would be required or we can proceed.
My lord, kindly peruse the page number 31, my lord. Already, one week to has been released on bail, my lord. Page number 31, my lord.
When were you arrested?
My lord, I am shown arrested on 18/12, my lord. Already 25 days, my lord. My lord, he is the retired person, my lord. He was the last number. Further detention is not required, my lord.
Yes. Co-accused has been released on bail on the ground that he was behind the bar for last 20 days.
25 days, my lord.
Co-accused.
My lord.
Already your lordship has taken up similar cases. A good number of cases have been registered.
This is
My lord,
land
this
matter.
type of cases. My lord,
Case diary would be required.
my lord, it's all respect.
My lord, in this case, already.
Immediately, short date may be
No,
given.
my lord, yesterday already he is on bail in connection with 325, my lord. Yesterday,
Yesterday he was.
That
saying-
indicates, my lord, he is habitual
lord.
offender.
Same,
He is-
same, my lord, you already.
Case diary would be required.
My lord, already co-accused has been released, my lord. That is a
But
20
but
20 days,
then
my lord.
the
20
case
days,
diary,
my lord, already I am 25 days, my lord.
no, but
Considering there is a.
parity does not, is not applicable without considering the facts. The co-accused was released considering the facts pertaining to his case. So nothing is before us.
Yes.
My
We are
lord,
fixing a
my lord,
short date.
I'm the retired, my lord. No, my lord, kindly produce the FIR, my
Why
lord.
your prayer was rejected by
My
the
lord,
trial court?
without producing any, case diary, my lord. Page number, my lord. Page number 29, my lord. An operative
No, we are fixing a short date. Heard Mr.
Harbor, my lord.
R. Burwal, learned counsel for the petitioner, also heard Mr. D. Das, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application, hence call for the case diary fixing
On 19.
19-1 for case.
Chief Level, my lord.
My lord, this matter, Lordship had the occasion to deal it on the last occasion, my lord. Amongst others, my lord, our prayer was a violation of the Supreme Court judgment in Ernest Kumar and subsequent Until's case, my lord. And my lord, item number 39 is also same matter. it did. Now, here in this case, my lord, there are 4 cases now. One is Cyber PS, one is Gorsuk, one is my lord, the Dispur, the present one, crime branch, and other one is Dispur. And my the same allegation in Dispur and crime, that's item number 39 and 62.
Item number 39 and 62 pertains to same FIR or
My lord, different.
different.
No, same FIR. If your lordship would kindly have the FIR in item number, present item, my lord, present to crime, na?
Crime 9.
Yes. In the FIR, there is no allegation, but in the forwarding report, there is a, my lord, remark. Please come to the forwarding report at page number 36.
what is the allegation in the FIR in this case?
Original, but there is no allegation against the petitioner. FIR is at page 22, my lord. Completely, huh? My lord, my
Case diary
learned,
would be,
my learned friend says the case that in other cases there, the crime branch case, 9 of 23. He says in his son time. But I'm on a slightly different plan. You will kindly hear me out for 5 minutes, my lord. Now, my lord, I was working as a sub-registrar in Guwahati. Now, basic allegation against me is that I issued certain certified copy of a deed which has turned out to be fake.
later on.
And those deeds are of 92 and 95. I do not know when I was born or not. One is 92, other is 95. And I joined service in 96, my lord. The basic allegation is I issued certified copy of a deed which is, stated to be fake. Now, my lord, 4 cases are pending against me. In 2 cases, I have got bail. In my lord, Cyber PS case number, Cyber PS case number 12 of 23, I am on interim anticipatory bail. And my lord, in Gorsuk PS case number 324 of 23, exactly the same allegation, my lord, I am on absolute anticipatory bail. Now, my lord, the other day I placed the judgment of Kamal Datta, which was rendered by this honorable court, relying upon the honorable Supreme Court judgment in Uday Chand's case, where the honorable Supreme Court said, my lord, if there are several cases pending against a particular accused, then, my lord, while producing the CD,
The prosecution has a duty to mention all the cases which are against him.
Yes.
Tomorrow, if I am released in one case, I cannot be taken into custody. And that is the only, my lord, safeguard. Now, following Uday Chand, my lord, our High Court has rendered the judgment. Kamal Datta, I'll just place it, my lord. The other day also. My lord will kindly come to page number 4. Pages are down below, my lord, towards the bottom. The sentence starting with secondly, with the lordship's got it?
Yes.
Yes. Secondly, when this court had granted bail in Pasighat PS case number so-and-so, this court was not informed that the accused was also wanted in Basar PS case number 9 of 14 and Itanagar PS case number 304 of 2013. Even the learned judicial magistrate first class Pasighat who had passed the consequential order on 19/11/14 following the bail order of this court was not informed that Sri Tapan Datta was wanted in those cases where he is an accused. It is stated in the affidavit that Tapan Datta was arrested by Pasighat police on requisition of Basar police from outside the court on 19/11/14 at about 4 p.m. He was handed over to Basar PS police station on 20/11/14, who in turn produced the accused before the magistrate on 21/11/14, which is again beyond 24 hours of arrest on 19/11/14. Arresting the accused in a different case from outside the court, where he was granted bail without disclosing to the court about need to arrest him in another case is wholly unacceptable. In Uday Chand versus so-and-so, the apex court deprecated the practice of withholding information from the court about requirement to arrest the accused in other cases. It was held that if after order of bail is passed by the court, the authorities of the state consider it fit to arrest a released person for any other offense, it was their bounden duty to apprise the court before taking such person in custody. In the facts of that case, the arrests were held to be contrary to the bail order passed by the apex court, and accordingly, petitioners of that case were released from custody, treating them to be free citizens. Having regard to the above, this court is of the view that that accused Tapan Datta Das should now be released as his continued detention has become clearly untenable. As noticed above, he had been granted bail by this court in 1 out of the 4 cases, that is Pasighat case. He shall now be released on bail in connection with all other 3 cases, namely Itanagar, Basar and Aulo Payo case, subject to the condition that he shall cooperate. Well, that's the law. With the investigation of the case, that all the cases, all that he shall appear before this court on the next day. Accordingly, Sri Tapan Datta can now walk out of this court as a free man. He has produced before the High Court. Now, I am not praying to this extent, my lord. I'll comply with the formalities. But
No, but that prayer can be made only in a writ petition tribunal.
yes,
In this case, we are concerned
No,
with
I'm
the
not-
instant case.
I'm not seeking any direction of similar nature, but that principle, I'll pray, my lord, lordship will place into service the principles laid down in this case. Now, my lord, my lord, in Gorsuk PS case, my lord, the allegation was same.
Gorsuk 324,
Yes. Gorsuk
Which was-
324, that was also an
which
allegation
was lodged earlier
earlier.
than this case.
Yes. Now, my lord will kindly take the FIR in this case, and the other case I'll just show how why my lord, the subterfuge they are resorting to. Please come to the, my lord. In FIR there is nothing, my lord. Please come to the forwarding report at page 36. My lord will kindly come to page 38. Page 38, second sentence from top.
Yes.
During interrogation, accused Nitul Das stated in his statement before police that Sub-Registrar Ranjit Chaudhary, petitioner, put his signature in one forged deed, white dated so-and-so, against Doug number so-and-so. This language is also horrible. Actually, my lord, This is the original deed of which a certified copy was issued by the petitioner. That's the only allegation. And now kindly see.
No, you put signatures only on certified copy,
Yes,
not on the original.
not only original, that, the language is the faulty, my lord.
But language shows that you put signature in the.
How can I do 95 feet? How can I give, my lord? I was not even in service. Against Dag number so and so in the name of Mariam Bibi and took 20,000 rupees from Nitul Das. It is clearly indicated that already arrested person Nitul Ranjit Chaudhary, the then sub-register, did the forged deed with his own mind for his own benefit with the help of one person, Nitul Das, junior assistant, sub-register. This is the forwarding report in this case, my lord. My lord will kindly take the other matter, item number 39, for a moment, my lord. My lord will kindly come to page 29 of that. Page 29. Here also in this FIR, there is no allegation against the petitioner, my lord. Para 23. Somewhere in the middle sentence starting with during interrogation. Has the lordship noticed that, my lord?
Yes.
Yes. Page 29, para 23, fourth sentence. During interrogation, accused Nitul Chandra Das confessed that he had written the fake deed dated so and so, and fake deed was certified by sub-register Ranjit Chaudhary as true copy on 1721. Fake deed was in net for Moinul Haq, and Moinul Haq was given 50,000 to Nitul Das, and Nitul Das had given 4,000 to the sub-register. Same allegation. There are two cases. One is crime branch, and other is, my lord, the dispute PS case. My lord, I am on bail. I am on absolute bail. Is this the way my, rights should be dealt with, my lord? You consolidate all the allegations. You take resort to 173(8).
In this case, case diary was called for.
Yes, my learned friend has said the
It
case
is
that is
there.
available.
In connection with other petition, my lord, case diary has come. My lord.
Okay.
Now, whether your lordship will produce the case diary today itself or my lord, it will be fixed some other time.
Better, or
Well,
maybe in the second
we
half,
have
there
not,
is no
we have not
problem.
examined this case diary in connection with this petition.
No, since
No.
my,
No, their main submission is that during pendency of an earlier petition, the Uday Chand was not followed.
yes.
No, in this
And-
case, he is shown arrested, my lord. That is the information. At the time of shown arrest, he has been, he
One
was.
second. That
certainly
is one
informed.
point. The other point which I argued the other day was, lordships had also taken note of that. My lord, Anes Kumar said, in respect, here in this case, my lord, on the day when I was arrested, 409 was not there. So in terms of Anes Kumar, my lord, and until they should have given a notice under 41A.
Which case? In
Item dispute PS case number, my lord. If your lordship will kindly have a look at the page 27, my lord. Page 27, my lord.
no,
Reference dispute PS case number so and so.
let us go one by one.
Yes,
You take BA case number 165 first.
okay. My lord,
In BA case number 165 case diary.
my lord,
there-
here I was acting.
165. My lord, just now my learned friend had said that at the time of his arrest, 409 was not there. My lord, may kindly come to page 26.
No, that is not his submission in 165.
My
There
lord.
are
In
two-
other case,
In
my
other
lord.
case,
But in this case, it was there.
Says not
in
my
this
lord.
case, that is
In
not
that
his
case,
submission.
it may not be there, but in this case, he is, the
this
409
case-
is there.
He's not making submission
In this case, yes, that submission.
Therefore, we have to take one by one.
Yes,
Otherwise, you will also get
get
confused
confused, right.
and you will make me
No,
confused. also.
let a decision be taken on this petition, my lord, whether your lordship will.
Let us take one by one. Let us take one by one.
Yes,
Yes, that will
Take
be,
item number 39. We will take it later on,
Yes.
after we
Yes.
are done with this.
yes.
In this case, your submission is
but
that
apart from merit, my case is number one, my lord, the law laid down in Kamal Datta has not been followed. And the consequence of not following Kamal Datta is I am entitled to bail. Number one. Secondly, my lord, these are all procedural safeguards within the meaning of Article 21 and 22 of the Constitution of India. The state cannot tinker with my rights, my lord. The moment you do not follow certain procedural safeguard, it results in, my lord, violation of my right under Article 21. The moment my right under Article 21 is violated, my lord, this honorable court as a having, my
No.
lord, plenary power can always take
For
note of.
that, we have to peruse the case diary because
My lord.
whether Kamal Datta was followed or not,
Yes,
to arrive at that conclusion,
yes,
we have to find out whether on the date when this FIR was lodged,
yes.
whether police was having information regarding your
No. If I have understood Kamal Datta properly, my lord, while enlarging me on bail in that Gorsuk PS, they should have informed this honorable court or the court below.
This is the prosecution, my lord.
The prosecution's duty is to inform this honorable court. On the day when I was released on absolute bail, my lord, anticipatory bail, it was the duty of the prosecution to inform this honorable court that these are the cases which are pending against the petitioner. That is, if I have understood
Okay.
correctly, my lord. That they have not done. They have done not disclosed to this honorable court, my lord. My lord, what can be inferred in this circumstance is, because I have been released on bail by this honorable court, they have arrested me another case. And tomorrow they might say there is another transaction. Today, so they should inform your lordships.
no, but for that, the police must be knowing about pendency of this case because in this case you were not named.
No, my
It
lord.
is only during interrogation your name cropped up.
No, when my interrogation, that interrogation based on which the crime branch has arrested me was known to them on the date when bail was granted by this honorable court. The same authority is handling the case. There is one, my lord, there is one supervisory officer. The IO may not be aware of. There is a supervisory officer who is supervising all these cases. No, I am saying, end of the day, my lord, they will all fall under the broad heading of prosecution. But lordship knows in cases of this nature, there is a supervising officer, supervisory officer, maybe of the rank of additional SP or SP. They are all aware how many cases are pending against me. When they can find out how many cases are pending against me, they should inform the court as well, my lord. So in Kamal Datta, my lord, because he was not informed to the court, he was enlarged on bail. I am praying for the same relief in this case, my lord. And on merit, what is the allegation, my lord? I have issued a certified copy of a deed which is stated to be fake. Now that will be proved during the course of trial. Now, why my custodial interrogation is necessary, my lord? Now that deed based on which you have found some allegation that deed is always already with you. Why do you need my further custodial interrogation? And kindly take note of the fact, my lord, exactly on the same allegation, I have been enlarged on bail. I have given the benefit of, in spite of that order we have annexed, my lord.
Where is that on?
Yes, that order is at page number 33. That's it. My lord will kindly come to page 34. Last para. On the other hand, R.J. Borua, learned additional PP, produced the case diary before this court and submits that IO has collected sufficient incriminating material against the applicant that he is the kingpin of the offense. And therefore, Mr. Borua has vehemently opposed that the petition and contended to dismiss the same. Having regard to the submission of the learned advocate of both sides, and I have gone through the petition and documents placed on record, and also perused the case diary with the assistance of Mr. Borua, learned additional PP. It is not in dispute that pursuant to order dated 22/12/23, the applicant had appeared before the IO, and prior to that also on 14/10/23, applicant had appeared before the IO, pursuant to a notice received by him, issued under section 160 CRPC, thus it appears that he has been cooperating with the investigating agency. It also appears from the record that I have achieved substantial progress in the investigation of the case. And in view of the materials collected so far in the case, and also in view of the submission so advanced by the
This
learned
order
advocate.
is passed after perusal of the
Case
case,
name, of course.
case diary.
Yes. No, my lord, case
The-
diary will not reveal anything other than what Nitul Das is saying.
No, but what case diary would reveal,
Yes.
we would know only after perusal of the case diary.
Oh, that is true, my lord, but then the FIR is, in the FIR, there is no allegation against me. Only during the interrogation of Nitul Das, my complicity, the alleged complicity has propped up.
Yes.
So based on that, they have done it. So case diary will not include anything other than saying that Nitul Das has said, I have taken 4,000 rupees to issue the certified copy. That's all. In both the cases, same allegation. And kindly see, my lord, why two cases? Why this dispute PS and why these crime bunch cases? Because of the same allegation. The TT Anthony and all these cases have gone to the wind. My lord, end of the day, my lord, nowadays what has happened, the moment a person gets a bail, the police takes it as a problem, my lord, ego problem. All right, you have taken bail, now we'll show our power. They misuse, my lord. And these are misuse, my lord. Absolute misuse of power. Lordship will not permit this in my humble submission. End of the day, my lord, I'm a government servant. I'm still in service. My lord, idea of
In this
bail
case,
is,
you are behind the bar since,
my lord.
in this case, you are behind the bar since.
In this case, my lord, I was shown arrested on 9/1/24. Actually, I was arrested on 30/12/23 in the dispute PS case. I'm behind the bar since 30/12/23.
Yes, Mr. Das, case diary would be required on, what is your
Ma-
submission?
Case there will be required, my lord, because, my lord, I beg to draw your lordship's attention to the FIR, page 24, my lord. 2-3 lines, my lord. Page 24. With reference to the subject cited above, I have the honor to state before you that during investigation of the above mentioned case regarding passing of order of fake mutation case by mutation file number METDIS 2022-23. My lord will kindly note this. No, this is the year of mutation. Number so and so OMUT. It is found that the mutation order has been passed based on fake deed number so and so dated 31/12/95.
No,
Deed was,
no,
my lord, after 27 years,
maybe.
mutation was initiated, number one. Yeah, I mean- I understand. Then, my lord, forwarding report in the report says,
Whether case diary is available
case there is available now.
of this,
Yes, this crime branch
crime
case
branch
case number
case
9.
diary is available.
Yes.
You can go through the case diary.
Well, at 2
o'clock, my lord.
If case diary is available, because,
That is what I submit, I inform my learned
because
friend that
perusal of the
if-
case diary would be necessary. And if case diary is available, we will go through the case diary. And
Also, I have it at 2 o'clock, my lord.
you have, your submission is, you have something to more submit.
No, my lord, basically, these are my submission on merits, my lord. I'll say, my lord, my custodial interrogation is not required. And these are the procedural safeguards.
I'll
which
go
are-
through the case diary during lunch
Well,
and dictate order at 2.
My lord, my lord,
And
my.
how this, this one query,
Yes, my lord.
this Amol Datta guideline has been violated.
Yes.
That is, in
That
this
is my
case-
basic argument, my lord.
in this case, how it is violated?
It is violated because on the day, my lord, when in Gorsuk police PS case, the case diary was produced by
Gorsuk
the,
324,
yes,
which was earlier in point of time.
Gorsuk,
Okay,
yes. So
Yes.
on that day, when they, my lord, produced
this
the
was
case,
not in existence.
this is a case of 22 earlier.
This was, okay.
Ah. earlier.
Gorsuk was a later,
Yes, Gorsuk is a case of 23 and this case is of 22.
Gorsuk case number is
1 second. Gorsuk is, my lord, 324 of 23. Then, my lord, the dispute is of 384 of 22.
this is the present case.
Yes. No, present is crime branch.
Crime branch is,
Crime branch is 9 of 23.
so it was prior to the Gorsuk case.
Yes, yes.
So your submission is when the prosecution objected to bail in
Yesterday
Gorsuk
said, not only this
that-
case, there are so many other cases pending against him.
against the present petitioner, and due to violation of that, he is entitled to bail. Okay.
At 2 p.m.
Do you have any counter to this submission
Of which, my lord?
that this, then at 2 p.m. I will directly dictate that Uday Chand was not followed
Yes.
in the instant case. Their submission is,
No, Uday Chand might not have been followed in that case, my lord.
no,
But
as-
so far this case is concerned, my lord,
therefore I am
yes,
putting queries to you.
maybe, my lord, I have to examine the case.
Let me put the query. The submission of counsel for the prosecution is, the petitioner is that Gorsuk PS case number 324,
84, my lord.
384 of 23 was later in point of time. Before that, the present case, which is crime branch case number 9/23 was registered. When the prosecution appeared in Gorsuk PS case number 384/23, where the present petitioner took bail, you never.
324.
324, the petitioner got bail. You never informed in that case that crime branch 9/23 is also pending against me.
As well as dispute.
So their submission is that there is a clear violation of Uday Chand's guideline, and therefore on that ground only they are entitled to bail.
No, my lord.
On this, I need your
Yes,
on-
at 2 p.m. I will submit.
at 2
At 2
p.m.
p.m.
Okay, then I will, after hearing him, I will dictate.
My lord, and on merits, my lord, as I have already submitted, my only allegation is one co-accused has made a statement that he paid me something for, my lord, issuing a certified copy of a deed.
For that, your submission is custodial detention.
Not necessary.
Okay.
And he's already interrogated, he's in custody since 30/12, my lord. And today we are on 12th. And lordship will also have due regard to the fact that in a similar transactional case, my lord, this honorable court has already enlarged me on bail. At least
That is,
anticipatory bail.
no, in Gorsuk case, when you got bail,
Uh,
bail order is annexed here
yes, yes, but I'm giving the date.
at page.
Page 33. Initially, my lord, there was an added in it, then that was made absolute. 3/1/24.
You have annexed that order
Yes, both the orders have annexed in the petition, my.
at page.
Page 30 is the ad interim order. That is on 22/12/23. And final order is at page 33
Okay.
on 3/1/24. And in the cyber PS case also, I am on ad interim anticipatory bail. Thereafter, my lord, I was taken into custody.
So therefore, there is a violation of Uday.
Yes,
That is your submission.
that is my submission. And my lord, in Issu Devi's case also, Honorable Supreme Court, that AR 81 Supreme Court, my lord, where it is said, my lord, when there is a violation of, my lord, Article 21, then lordships will come to the rescue of the citizens. Diploma.
Itu Duta, itu Chamber of Dibo, along with the case right.
Please, your lordship, my lord, concurrent finding in the two trial courts, essential commodities at 3 months aside, and a 500 rupees fine. My lord, I am pressing for a suspension of the sentence and the revision petition for against the two judgments.
Heard Mr. A. Chamua, learned counsel for the petitioner. This is in criminal review, item number 9. A. Chamua for learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. This application under section 401, it is under what provision? 401 or 482?
My lord, actually, we practice is this, my lord, we write both 401 read with 482.
But both
Because-
jurisdictions are different jurisdictions.
No, my lord, there is the single judge's order, sorry, the trial judge, the CJM, where it was first convicted, that is also there. We write both, my lord. Lordship will take cognizance on this 401.
401 CRPC impugning the judgment and order dated 15/12/2023 passed in criminal appeal number 197/2018 passed by learned Sessions Judge, Additional Sessions Judge number 1, Kamrup Metro, Guwahati, whereby the judgment and order dated 27/11/2018 passed in CR case number 3334/2008 by learned additional Chief Judicial Magistrate Kamrup Metro was upheld by the judgment and order of the trial court. The present petitioner was convicted under section 7 within bracket 1 within bracket small a within bracket small Roman 2 of the Essential Commodities Act 1955.
Yes, 1952.
1955, and was sentenced to undergo simple imprisonment for 3 months and to pay a fine of rupees 1,000. What is your ground for revision?
My lord, what happened, my lord? The prosecution case is that I ran a hotel. Actually, the evidences that has come before the trial court was I live in a small thatched house made of bamboo and torture. And the veranda is used for, evidences says, my lord, in the evening, in a kerosene stove,
Not on facts. Where the first appellate court erred.
First appellate court erred is this, my lord. The first appellate court did not perceive on this fact. This is on record, my lord, through the from the evidences, that when this man was cooking something, this is his commercial, this is not a commercial spot.
Okay.
This is residential house.
So wrong appreciation of.
Yes, wrong appreciation.
Stop. Issue notice to the respondents, since respondent number 1 is represented by learned additional public prosecutor. No formal notice need to be issued to respondent number 1. Who will represent respondent number 2? PP may represent or notice will go.
Well, actually, PP shall, it's a government agency.
Notice, let's say.
Uh-huh.
No, PP not. Government advocate.
Well, some
Government-
notice upon the GIA some.
Government advocate.
The learned additional public prosecutor, learned counsel for the, as regards the
Sufficient notice.
respondent number 2 is concerned, the petitioner shall take steps for issuance of note, for service of notice to respondent number 2 through government advocate Assam,
Senior government advocate.
senior government advocate Assam. The petitioner shall take steps for serving a copy of notice along with the petition and the annexures to the senior government advocate Assam. Senior government advocate Assam within 3 days from the date of this,
And from tomorrow, it will close, you know,
within next 3 working days.
next year.
Working days from the date of this order. Let this matter be listed thereafter after 4 weeks. In IA, this interlocutory application has been filed by the petitioner
For suspension of something.
for suspension of the sentence imposed on the petitioner by the by the Court of London Additional Chief Judicial Magistrate, Kamrup Metro Guwahati, in CR case number 3334/2008,
Additional CJM Kamrup Metro.
which was upheld by the learned additional session judge number 1, Kamrup Metro Guwahati, in criminal appeal number 197/2018. The petitioner has impugned the aforesaid judgment by preferring a criminal revision petition, which is registered as criminal revision petition number 13/2024. By the impugned judgment and order, the petitioner has been sentenced to undergo simple imprisonment for
3 months.
for 3 months, along with a fine of ₹1,000 under section 7 within bracket 1 within bracket small a within bracket Roman 2 of the Essential Commodities Act 1955. Learned counsel for the petitioner has submitted that the petitioner has good grounds to pursue the criminal revision petition filed against the impugned orders, and there is a chance of success in the said criminal revision petition. As the sentence imposed on the present petitioner is for a very limited duration of 3 months, hence, unless the sentence is suspended during the pendency of the criminal revision petition number 13/2024, he would be prejudiced in the event of success in the said criminal revision petition. Therefore, during the pendency of the criminal revision petition number 13/2024, the sentence imposed on the present petitioner by the impugned judgment is hereby suspended, and this interlocutory application is disposed of.
I'm obliged.
Oh, I am.
May it please the Lordship. Lordship, this petition, by this petition, my lord, petitioner saying his Zimma of his auto vehicle, my lord. Rejection order page 24. It was a new auto, my lord. Thereafter, the registration number was issued after the CC. Page 24 is the implemented.
Page 24.
Page 24.
Why it was rejected?
It was rejected, my lord. Page 24 says even it without report of IO. Then page 25 says, my lord, at the stage of investigation, my lord. Page 24, first para says, my lord, IO has failed to produce the report. Even then, my lord, rejected without report, my lord, page 25, due to investigation.
There is a division bench judgment.
Yes, my lord. I am also division bench, also Sundar Bhai Ambala.
No, of our High Court. Where is that judgment? There is a division bench judgment which deals with the issue which you are raising.
my lord.
You bring that judgment on the next day. Heard Mr. M. R. Kondokar, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. This application under section 397 of the Code of Criminal Procedure, 397/401 of the Code of Criminal Procedure, 1973 has been preferred by the petitioner Ali Hussain Mullah, impugning the order dated 28/11/2023, passed by learned Special Judge South Salmara Mankasar, where in connection with South Salmara PS case number 274/23 corresponding to GR case number 844/2023, whereby the prayer for Jimma of the auto, what is the vehicle?
Auto, man, air auto,
Ape auto
of the
seized
three-wheeler.
in the said case was rejected by the present petitioner. Issue since
Paragraph 2, my lord. Details of the.
let a you have anything required?
Lordship, if I look into the Lordship, the order copy, 25 Lordship, rejection, it has clearly stated Lordship, the first para, last few lines. However, under section 457 of the CRPC has the jurisdiction to give custody of the seized property article at the stage of investigation when this seized property are not produced. And in the
Learned counsel for the petitioner also submits that he will produce the relevant citation of he will produce the ruling relevant to the present case on the next date fixed and prays for a date or prays for some time for the same. The prayer is allowed. Also, learned additional public prosecutor. Let this case be listed again on when you want it.
That on 20.
23.
Well,
23 for 23-1 for admission hearing.
23rd.
the report, it would be better if the report will be.
No report, no, we have to deal with only law question,
Okay.
question of law.
But here it is stated.
In the
that-
meanwhile, let also a report be called for from the investigating officer of the case as to whether the retention of the seized vehicle is necessary for the continuation of for the sake of investigation or not. Let this case be listed on 23rd one.
I am.
Let me do it. With preliminary revision against the order, impugning order dated 18/7/2023. First in criminal appeal number 17 of public 2022. About upholding and conviction of the sentence by the judgment and order dated 22/6/22 passed by the learned additional chief judicial magistrate, Nagaon in NI case number 14/2017. And my lord, whereby convicting and sentencing the petitioner to undergo imprisonment for 3 months and to pay of fine rupees 2,50,000. As
You are in jail or outside?
I'm outside.
Heard Mr. B. Buragohai, learned counsel for the petitioner. This criminal revision petition has been filed under section 397/401 of the Code of Criminal Procedure by the petitioner Orup Deka, impugning the judgment and order dated
18/7.
order dated 18/7/2023, passed in criminal appeal number 17 within bracket N/22 by the learned additional sessions judge number 3 Nagaon, whereby additional session judge number 3 Nagaon upholding the judgment and order dated 22/6/2022, passed by learned additional Chief Judicial Magistrate Nagaon in NI case number 14/2017, whereby the present petitioner was convicted under section 138 of the NI Act and was sentenced to undergo simple imprisonment for 3 months and to pay a fine of rupees 2,50,000 as compensation to the respondent number 2, and in default of payment of fine to undergo simple imprisonment for 1 month. Issue notice to the respondents, since here you have made state as a party, since the learned additional public prosecutor has appeared for respondent number 1. No formal notice need to be issued to the respondent number 1. However, as regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 working days from the date of this order, returnable after 3 weeks. Stop. Next, interlocutor application. Heard so and so. Heard Mr. B. Bura Gohai, learned counsel for the applicant. Also heard Mr. K.K. Das, learned additional public prosecutor. This interlocutory application has been filed under section 397 of the Code of Criminal Procedure. It should not be under 389. Power is under 397 only.
394.
Because this is not an appeal.
Yes,
You have filed it under 389.
I filed one, but I have stated here, here is here in the main petition.
Okay. File
For suspension.
section to mention no koribo. File for suspension of the sentence imposed on the present petitioner by judgment and order dated 22/6/2022, passed by learned additional Chief Judicial Magistrate Nagaon in NI Act case number 14/2017, which was upheld by the learned Court of Learned Additional Session Judge number 3 Nagaon in criminal appeal number 17 within bracket N of 2022. Stop. The said judgments are impugned by the present petitioner by preferring a criminal revision petition which has been registered as criminal revision petition number 15/2024. Issue notice to the respondents. Since respondent number 1 is represented by learned additional public prosecutor, no formal notice need to be issued to the respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 within next 3 working days from the date of this order, returnable after 3 weeks. However, in the meanwhile, as the petitioner has been sentenced for a limited duration of only 3 months. Sentence for imprisonment for limited duration of 3 months only. 3 months. What is the sentence?
3 months.
3 months only. The the sentence, comma, the sentence in the same shall remain suspended till next returnable date.
Alright.
List this case accordingly.
And he may be allowed to remain on previous. bail.
And he may be, and the petitioner is allowed to remain on previous bail granted by the lower court. Which court granted you previous bail?
Learned
Additional.
additional Chief Judicial Magistrate Nagaon.
Previous bail granted by the Court of Learned Additional Chief Judicial Magistrate Nagaon. List this case accordingly.
Obliged, highly obliged.
Made to your lordship. In this case, the other law, your lordship, it's a revision petition, my lord, for seeking custody. I have the impugned order is that my lord, page 21
Jimma for
of personal vehicle, my lord, I-20 to mobile phone, and my lord, the sealing of the cold storage.
why Jimma was rejected? Where is the rejection order?
Yes, my lord, page 21. Your lordship, my lord, kindly go through, my lord.
Yes. Jimma was granted to you.
No, my lord.
No.
Oh, my lord. And my lord, talked about section 11.5, but there should have been, my lord, section 11.1. Take out, actually. And I want to place the law, my lord, that we don't have any authority. Two judgments I have got. I want to place the provisions of the act, my lord.
No, why Jimma was rejected?
Jimma was rejected, my lord, bank guarantee. Condition of bank guarantee equal to the provision so and so. 11.5. Vehicle was not carried cow, my lord. It was seized from my lord Guwahati only, Khanapara. It's a personal vehicle. Mobile phone, nothing to do with the mobile phone.
Which has been seized in Is it
Page 5, if your lordship kindly come to page 5, my lord. Paragraph 4, I want to read.
before page 5? You are impugning judgment order dated 21. Order
ma'am.
dated 2/1/24.
Maybe pardon.
At
124, yes,
page
ma'am.
21.
Yes, ma'am.
At page 21.
Yes, my lord.
So it
Is
is
it-
only
it
2
is-
pages order.
Yes, my lord.
On both sides, where is the case diary? Now section.
They want bank guarantee of the vehicle, my lord.
On being satisfied that tenant merchant immediate privacy. Has been granted. Yes.
Whole total case is a misconception, my lord, because without authority, my lord. Page 5, my lord, deputy inspector, the Jimma of the court also. The prior petition was rejected, stating he had not furnished bank guarantee as per section 11(5) of the Assam Cattle Preservation Act. The donor failed to appreciate that.
But
As per
Jimma,
section
bank guarantee would be furnished only after order of Jimma.
order.
Whether any order of Jimma was passed,
No, my.
then question of bank guarantee is a later question,
Subsequent.
question. So
Here, my lord, that under the Food Safety Act, they don't have any jurisdiction. I have quoted various provisions, my lord. And decision also, first time sitting, my lord, that as per section 37, 38, and 41 of the Food Safety Act, that I have enclosed the, my lord, enclosed the particular section of the act, my lord, for perusal of your lordship.
no, you are impugning the Jimma order, Jimma rejection order.
But my lord, basic thing is the police don't have any jurisdiction because, my lord, as per section 11(1), he has got, the IO has got only SI, sub-inspector of police, he has got jurisdiction over his area only. But he has seized the vehicle and other things, my lord, from Guwahati only, where he do not have his jurisdiction as per that Cattle Act, my lord, 11(1).
Whether these things were pleaded before the court when impugn order was passed, because we will now only see
Yes, ma'am.
whether
Petition-
impugn order
yes,
is.
ma'am. Petition, all these things are there. There's a local advocate appeared, my lord. All these things are, my lord. If you let's see one, my lord, I can give the also. All these things are, my lord, pleaded, but my lord,
Yes,
section
make your
11(1),
submission.
if your lordship see, page 9, I have quoted here. There also in the petition I have prepared from page 9, paragraph 9, the deputy solicitor said that 11(1) of the Assam Cattle Preservation Act 2021, a police officer not below the rank of sub-inspector, paragraph 9, my lord, or a registered veterinary officer or any other person authorized in this behalf by the state government shall have the power to enter and inspect any premises within the local limits of jurisdiction of such person where he has reason to believe that an offense under this act has been or is likely to be committed. The IO. So, on the other hand, my lord, paragraph 10, I have again quoted, my lord, the provision that the preamble of this act says that Food Safety and Standard Act 2006, an act to consolidate the laws relating to food and to establish the Food Safety and Standards Authority of India for laying down science-based standards for articles of food and to regulate their manufacture, storage, distribution, sale, and import to ensure availability of safe and wholesome food for human consumption and for
No, but
matters
whether this
connected.
case was registered under food safety?
No, my lord. And police don't have the authority also as per act. Here, my lord, that food is defined here at page 10. And my lord, section 31. Now I'm reading, my lord. Section.
Yeah,
Yes, ma'am.
I am very limited query. I have,
Yes, ma'am.
you are impugning an order of
Jimma.
Jimma.
Yes, ma'am.
So
Not giving Jimma.
in
Refusing
this
to reject
revision
the Jimma.
petition, I will see whether that order is okay or not.
Yes, ma'am.
Only that much. But you are
But-
raising many issues
Any question, my lord?
which
Whether police-
which was not considered by the
which
trial
was
court
not considered trial
while
court.
passing the impugn
Yes,
order.
my lord. Don't have much
Those
idea
things-
probably, my lord. Don't have much idea. I don't know, my lord. All these things were there, my lord. That the
In this
police-
revision
police
petition,
is
my
acting-
jurisdiction is
the
limited.
police is- No, my lord. High Court has got empower.
No.
High Court has got my.
I am not on,
High Court has got my.
in this revision petition, whether the impugn order is,
Yes, your lordship,
His-
as your lordship like, but my lord, I want to apprise your lordship that police is acting beyond jurisdiction. They are not authorized to take sample, they are not authorized to help people, arrest people like this.
then
So
you
it's
have to
acting
approach
beyond
this
jurisdiction.
court under
Then
other
the court
jurisdiction.
Come to rescue the citizen, my lord. Hamper
Then
is
whether
hamper
criminal
power.
revision, in criminal revision petition where you have impugned a specific order, you can raise these issues.
No, you have to apprise the court, what is the background of the case.
Okay.
That is very important. Otherwise, it is not a normal case because here the police without jurisdiction, my lord, they are acting. The court has to come forward and interfere in it, my lord. Otherwise, my lord, citizen will not be protected. Because without jurisdiction, working without jurisdiction, this is very important, my lord.
No, but this is not a 482 petition.
Forest petition in Mumbai, my lord. Forest petition.
Here you limit, you
Here
make,
only for Jimma. Here only for.
yes, what
yes,
is
my
your
lord.
submission in this case?
So, my lord, since they have acted beyond jurisdiction, my lord, and two cases I have also placed before your lordship, my lord. If your lordship want, I can read that only the Food Safety Act has got power to interfere on this case. They can examine, they can seize, they can seal, they can fine, they can give imprisonment, only the Food Safety Act. And they, if there anything there, they can report to the food safety officer, not act upon them. But they have acted here like a Hindi film villain, my lord. Coming from Srirampur Gate beyond, without jurisdiction, they have picked up person, they have picked up vehicle, mobile and everything. So it's fairly illegal. Your lordship may kindly give the Zimma, my lord. Because of sealing of the one part of the cold storage, that has been, business has been affected, and all tenants, because we are, the petitioner is giving it is on rent. So the other tenants, they are unable to take out peas, paneer, matar, and so many things, chicken product. Because the tenants are suffering, my lord.
Those issues are not be,
Not
issues
the-
is
I have
whether
to
that
apprise-
vehicle,
Vehicle, yes. Vehicle, it is not found in carrying cattle, my lord. It is, my lord, personal vehicle, I-20 car. There is no question of taking this personal mobile, my lord. Why they have taken, transferred the mobile data, but why they have to keep the mobile handset, my lord? And on the other hand, sealing of the cold storage. Without power, without authority, or they have acted. So if your lordship give protection, then only, my lord, people will be rescued. Otherwise, my lord, this.
Yes, Mr. Das.
Yes, lordship. I have not found any illegality in the order, lordship. Because it is
Without power, they are acting. This is the main
11.5.
basic question.
section 11, page 22.
11 on.
Moreover, in the page 21 also, second paragraph, lordship. Page 21, second paragraph.
11 is for carrying cattle. Personal thing.
Ms. Sakia,
Yes, my lord.
now what is your submission that cattle
Cattle Act, my lord, does
Is
not
not-
apply because it's a deals with live cattle. Live cattle. Section, my lord. I'm submitting. my lord.
where is that
Yes, my lord.
statement in the,
Given on petition on the my lord. The petition, yes, Section 5. Section with us now.
whether investigation is completed?
The investigation, I don't know, my lord, about that money. It's 5 cents.
We'll call for the case diary.
In his report, lordship. A report may be called for
In the
regarding
premises
the
also,
whether this vehicle is required or not for investigation.
it's a personal car, my lord.
As
It does not
Zimma,
found
lordship.
for it is not found, my lord, for carrying. Here, they have picked up the car from the Guwahati, my lord. They have not found that, my lord, carrying cows or anything, my lord. Section 5, I'm reading, my lord. Section 5, notwithstanding anything in any other course or in use of the contrary, no person shall slaughter or cause to be slaughtered or
No,
offer
heard
or
Mr.
use this to
Heard Miss N. Sakia. I am calling for the case diary.
be-
And
Is there called by another court also, madam,
when?
today? 482 petition.
So let this,
Matter be clubbed
you-
together.
these two,
Jimma, your interim order, your lordship may kindly give my lord, otherwise the phone, my lord, business phone, my lord.
phone,
that has been-
phone is not the subject matter, no?
They have
Because,
kept the handset, my lord.
but
The petitioner is unable to operate business, my lord, because of the nowadays, every business is linked with phone, my lord. Booking and other thing. Phone also they have kept, vehicle also kept, vehicle not found in carrying, my lord, carrying any cow. So why should they take the vehicle with their driver from here? Totally illegal things they are doing, my lord. I don't know who
this
this is.
22/12/23 report is available.
20?
The report of the IO which was
Yes,
produced.
my lord, yes, my lord. That is also, my lord. A report submitted before, my lord, that, page 23, my lord. Totally illegal things they are doing. A Food Safety Act, my lord, everything is under Food Safety Act. Law is very clear in this regard.
And this plea you have raised in your 482 petition.
Yes, my
You
lord.
have preferred a
No, no,
482,
Jima petition is separate, my lord.
but you have preferred a 482 petition also.
Yes, my lord, because the,
uh,
so many judgments are
Raising
there.
the maintainability of that case.
Exactly.
So both the cases should be
Come
taken
together.
up by the same court.
That also-
Otherwise, if I hold here something that
Your lordship, please, my lord, but my lord, if your lordship give at least interim Jima of the vehicle phones and the, my lord, posters, later on it will see, because that is not maintainable, my lord.
heard Miss M. N. Sai-
Unnecessary harassing of the businessman, my lord. That's why the Food Safety Act has
No,
come
but
for
if-
rescue of the businessman. my
But
lord.
let it go before that court. Which court it is?
Now,
been?
my lord, now, my lord, the vacation has come.
So I will give a direction, both cases may come before the
That is
same.
together, but your lordship can pass independent petition, my lord, now. Later on a hearing, we will take together, my lord. But at least I am praying for interim Jimma, my lord. More than 1 month, the business is suffering, the things are rotten in the cold storage, who will pay for it, damage, my lord? Have to learn damage case for police also, my lord, because all tenants have kept their things. The tenants are, my lord, they are
The
facing
cold
trouble.
storage is not in question.
Cold storage, my lord, not necessary for them, my lord. Under catalog, how a cold storage can be locked. So your lordship have to come forward and rescue, my lord. Otherwise, my lord, this is, I am ready to place all decisions, all sections. The law I have annexed the provisions of the
Heard
FSSA.
Miss N. Sakia, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This revision, this application under section 397/401 of the Code of Criminal Procedure, 1973, has been preferred by the petitioner Abhijit Sakia, impugning the order dated which order you have impugned?
Page 31, my lord. Ordered at the 2/1/24, 2nd of January,
Order dated 2/1/24,
24, passed by the learned
passed by learned Subdivisional Judicial Magistrate
subdivision
Metro
magistrate.
Gosaigaon, whereby the prayer for Jimma filed by the present petitioner of the Oppo mobile handset as well as vehicle bearing registration. The petition was for vehicle or
Yes,
only?
my lord. All, my lord.
But in-
Vehicle, cold storage and my lord, phone.
But in the order sheet, it is mentioned that only vehicle, Jimma petition was for only vehicle.
Yes, but my lord, in the order, my lord, they have quoted all the things, my lord, stated that two mobile phones, Samsung, SIM card.
But your petition was for, my query is petition is
Prayer, my lord.
not in this case. Before the SDJM, when you filed the JIMA petition,
Yes, my lord. For all the things, my lord.
where is that petition?
Seen the 29 years. Seen the petition, ma'am, filed by the petitioner and so here for Zimma vehicle bearing number 77, which has been seized by so and so, so and so. In the order not quoted, my lord. the
Order
petition-
only quotes about vehicle.
But my lord, I can place the petition, my lord, at 2 o'clock if your lordship want, that everything was there, my lord. The honorable court has not, my lord, quoted,
JIMA of the,
but the petition.
whereby the JIMA of the vehicle was vehicle bearing registration number AS01BR 4071 was rejected.
Page 22(1), that is there.
Was rejected. Perusal of the case diary. Learned counsel for the petitioner has also submitted that the petitioner has preferred an criminal petition bearing number, criminal petition number
16 of 24.
16 of 24, whereby what you have challenged in that entire proceeding.
Proceeding, my lord, because under the law.
No, what you, I'm
Quashing of the FIR, my lord,
where the
entire proceeding,
Where
quashing of the proceeding.
petitioner has challenged the entire proceeding based on the, which was instituted on the basis of the FIR lodged against the present petitioner. And same is also pending before this court, and case diary was also called for in that case. When the date is fixed?
It is fixed, my lord, date is not fixed, my lord, after 3 weeks. That is, my lord, because because of cases on the diary, my lord, that has been little late, my lord.
Case diary has not been called for.
Call for,
So some date must have been
date
fixed
not fixed, my lord, 3 weeks,
after,
after 3 weeks.
in which
Then it
case
is
the
tagged together.
case diary has been called for, and the said case has been listed, has been directed to be listed after 3 weeks.
This case will affect, my lord. Here I have got certain specific file. There, my lord, that will go slow, my lord, that will, because they will file something.
Let the case diary be called for in this case also, fixing, give a short date in this case,
24.
fixing 24/1 for case diary. Since learned additional 22/1 for case diary. Since learned additional public prosecutor appears for the sole respondent. No, the service of notice on the respondent is deemed to be completed. Let this case be listed again on 22/1. 22/1.
Yes, my lord, but some interim protection will be given, my lord, what they will do with the mobile phone and my lord sealing of cold storage.
After,
Is there also? one
because we
given?
don't have copy of petition, nothing is on record. After perusal of, not at 2 o'clock, on
Because that petition I didn't get, my lord.
21,
But my
22.
But my lord, your lordship kindly otherwise see the business condition, my lord, because of the mobile phone.
On
because of the
22.
Mobile phone, number one, mobile phone, because of the sealing of a cold storage, why the common people should suffer? They are tenants only, they are doing business, there are lakhs of.
You will
rupees
get
outside.
ample opportunity to argue on 22.
You have to read it. Yes, case number 25.
Petition number to change. for you. Yes.
Washing of an FIR, my lord, that's a. Find the FIR of 20.
14.
Malad, may I very shortly explain the grounds, my lord,
Yes.
basing on which I am, my lord, preparing this application.
Thank you.
My lordship may go for the, my lord, the page number 20, that's a very short FIR, it's my lord, accidental case. 20, my lord. My lord has got it, applied a final order.
What is this?
My lord. Which one, my lord?
Page 20.
Page 20 is the FIR.
Page 20 is FIR against you,
My lord, FIR against,
Okay.
my lord,
which you want to quash.
my lord. My lord, my
What is the ground?
My lord, now, my lord, Lordship may kindly that, my lord, take into note that, my lord, that the registration number and the, my lord, the type of the vehicle that has been mentioned in the FIR, my lord. It's a, my lord, Bolero pickup, my lord.
Yes.
Bolero pickup, and thereafter, my lord, this, my lord, registration number bearing so and so AS06 BC 5049. Then, my lord, Lordship may kindly turn the next page 21. Next page 21, my lord. The fact hearing is, my lord, it is a very strange kind of, my lord, fact hearing. My lord, this, I'm a, my lord, on the, my lord, registration number is, my lord, of that, which has been mentioned in the FIR resembles with my vehicle, my lord, but the nature of the vehicle is different. My one is, my lord, Tata Dia vehicle. I'm, my lord, connecting this registration certificate on the right side bottom, my lord. It's a little bit, my lord, small. Right side, my lord, model thereafter, my lord, that MFG by that a Tata.
Okay. According to you, your vehicle is not Bolero.
My lord, my
Your vehicle is Tata DI.
Tata
vehicle.
DI, my lord. The prima facie on the basis of the record, my lord.
Therefore, it should be quashed.
No, my lord, there are some other grounds is there, my lord. Other grounds is there. Because,
What?
my lord, it's that, my lord, there is, my lord, Lordship may that the accident, the Lordship may take note of the, my lord, FIR once again. My lord, accident occurred in, my lord, as per allegation, 7/11/2023, my lord. And the FIR has been registered on 16/11/2023. Now, there is no any explanation of delay. My lord, moreover, the another significant fact is that, my lord, as per the allegation, my lord, they are saying that when that the vehicle hit, and thereafter the my lord, deceased has been admitted to the hospital. And, my lord, so far as I know, my lord, there is some formalities when the my lord, accident person is my lord, admitted in the hospital. Even, my lord, that has to be intimated to the police. It may not be by the, my lord, the informant, but by the hospital authority.
No, what is your grounds?
My lord, now, my lord,
For
your
what?
lordship, my lord, that why I'm trying to substantiate is that, my lord, if the accidents is occur, that, my lord, that there must be some, my lord, GDNTs there, my lord, on the very day of, my lord, occurrence.
You want to say that no accident had occurred?
My lord, that I'm not saying maybe, but, my lord, my vehicle is not involved, my lord, because my one
That is a
different.
question of fact,
My lord,
which will
prima
be
facie-
revealed in investigation. If your vehicle is not involved,
My lord.
the police will submit FIR.
My lord, that will be otherwise, my lord. I am, my lord, annexing some other documents to substantiate that, my lord, at that particular moment of time that, my lord, the vehicle is lying in my premises. 2, 3
No,
certificates.
all these things have to be told to the investigating officer. Can this be ground for quashing FIR?
No, my lord, because it's, my lord, the informations are bogus, my lord. If prima facie does not constitute my involvement, even, my lord, they have
But
to.
prima facie it shows that a vehicle.
Then, my lord, the accident was, my lord, occurred in the, my lord, in the place of in my lord, Karbi Anglong. And my lord, vehicle was there in my premises in the district of Dibrugarh, my lord. And regarding that aspect, my lord, your lordship, my lord, kind satisfaction. I have, my lord, submitted three certificates, my lord.
No,
That have
all
been-
these you can submit before the IO.
My lord, I have communicated. I have communicated thereafter, my lord, they are not, my lord, paying any heed to my request. And, my lord, I'm very much
This is
lawful, even,
not
my
a,
lord.
yes, Mr. Das.
My lord, what I'm trying to say is, my lord, they are.
Das,
my lord,
what is your submission?
My lord, it will be a matter of my lordship whether this vehicle is not or not, my lord.
That's why I'm
And
saying, my
they
lord,
may also connect with the, my lord, contact with the IO lordship.
my lord, we have approached. That's why, my lord, I'm, my lord, only praying for the lordship may kindly, my lord, that a report may be called for as per your lordship, my lord, convenience. And, my lord, till date, that my lord, I'm not my lord, checking for any stay. That, my lord, only a direction we should not to, my lord, seize my vehicle. Because my lord, that if the police will appear to in my premises and if they will, my lord, interrogate the witnesses, everyone will reveal. My lord, the Gaubra had issued a certificate that only that my lord, and that on that particular day of occurrence, the my lord vehicle was lying in my premises. There is a VGP party of the place also, my lord, issuing a certificate, and your
I
lordship
don't
can-
see any merit in your case.
No, my lord. That's why
Heard Mr. D. Soikia, Lanet, I'm issuing notice.
BK Das.
BK Das, Lanet, BK Das, Lanet Counsel for the petitioner. Also heard Mr. KK Das, Lanet Additional Public Prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Chandan Hajorika, praying for quashing of the FIR registered under FIR on the basis of which Khaironi PSP case number 82/2023 has been registered under section 279/370 279/304A of the Indian Penal Code. Stop. Issue notice to the respondents. And call for the scanned copy of the case diary of Khaironi PS case number 82/2023. Stop. Issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards the respondent number 2 is concerned, the petitioner shall take steps for issuance of notice to respondent number 2, returnable on 29th of January 2023. Let this case be listed accordingly on 29th January.
I'm obliged, my lord, just may I make a prayer, my lord? That I'm not, my lord, that my lord, the accidents is occurred in the Kabi Anglong.
So what is your prayer?
Now, my lord, can it be possible only to the till next day to, my lord, keep evidence my appearance? Because they are, my lord, the investigating authority are insisting me to appear there. And my lord, my lord, that the situation therein is, my lord, so horrible, even in Kabi Anglong, my lord. Personally, I
For
cannot
that,
appear.
you have other reliefs.
Hmm.
This case is a very weak case.
My lord, perhaps.
You don't burden it by making, otherwise it will crumble. Let this case be listed again on 29 January.
Item 14.
Obliged.
My lordship. My lord, petitioner is, my lord, appearing before your lordship, my lord, against the order dated 16/6/2023, my lord. Whereby, my lord, NBW it was issued, my lord. Page 24, my lord. Can you look at it? Page 24, my lord. Very nice.
Yes.
Accused Mr. So-and-so is absent. The summons against the accused Dharmendra Gogoi has returned unexecuted with a report that he has not found at a given address, and it has been learned that he has been staying away from his house for a long time. And this is Mr. Someone was not executed, Mr. Even though Mr. NBW is issued, the same.
Thereafter, what happened?
Thereafter, the same thing is happening, Mr. Again, Mr. Page 25, Mr. Not executed, NBW not executed, Mr. Till then, Mr. Proclaim and PN was issued.
No, you have to make submissions properly. After NBWA,
No, I have no knowledge about this case, madam. Till today, madam. No, madam, no, madam. Madam, neither police has visited my place, madam. No, madam, someone has been received by me, madam. Till that, madam.
now what is this? What is this stage?
This is the last order, madam.
The case has been filed.
Yes, has been filed.
Okay.
The case of madam, initially FIR was lost, madam, under section 363, madam. And madam, Sasita
No,
submitted.
case has been filed and A standing warrant of arrest has been issued. You have not impugned that order by a subsequent order, that is order dated 30/12 to 2023. A standing warrant of arrest has been issued against you.
My lord.
You are neither making submission nor you have impugned that order. Have you challenged that order?
My lord, all of, my lord, the order dated 16th, my lord, and all subsequent orders, my lord. I have challenged, sir.
Appear
Because-
before
I
the,
will appear with different matter, I will appear before the- on a different matter. Charge sheet was submitted under section 366, my lord.
heard Mr. A. Khandokar, A. Khonikar, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely
Dharmendra
Dharmendra Gogoi, impugning the order dated 18/9/89
16/6, my lord.
16/6/2023,
And all other,
And-
all subsequent orders.
all subsequent order issued by
SDGM, M.
SDGM Dhokha Khana in
PRC case
PRC
number.
case number 48/2023. Stop. Learned counsel for the petitioner has, you have been shown as an absconder in the
Absconder, my lord, in the subsequent.
learned counsel for the petitioner has submitted that in PRC case number 48/2023, charge sheet has been laid against the present petitioner, showing him as an absconder in the charge sheet. Which said charge sheet has been laid under section
366.
366 of the Indian Penal Code. Learned counsel for the petitioner has also submitted that initially the committal court, that is the court of learned SDGM named Dhokha Khana, had issued summons to the present petitioner. However, by order dated 16/6/2023, when the said summons, when the summons issued to the present petitioner returned without service, the committal court issued non-bailable warrant of arrest against the present petitioner, and thereafter it went on to issuing orders for proclamation of the petitioner as an absconder and orders for attachment of property, and ultimately by order dated 30/12/2023, the case against the present petitioner was filed by the learned committal court, and a standing warrant of arrest was issued against the present petitioner. Learned counsel for the petitioner has submitted that the petitioner is not aware about the pending proceed. When you came to know about this,
Last mother, in the month of the last,
where is the statement?
not, I have not stated my.
You are suppressing facts.
No, madam, I have not stated, madam, but I
That
came to
has
know.
to be stated.
I came to
When
know, I came to know, madam, last part of December, madam, that a case has been, madam.
Learned counsel for this sub petitioner has submitted that the petitioner came to know about pendency of the PRC case number 48/2023 in the month of December. He has also submitted that while issuing non-bailable warrant of arrest against the present petitioner, against present petitioner, it was issued. The non-bailable warrant of arrest was issued at the first instance only on the basis of the report of the process server that the petitioner has been staying away from his house for a period of for a long period of time. Now the petitioner has, it is further submitted by learned counsel for the petitioner that the petitioner is willing to face trial and he shall appear and cooperate in his trial before the learned trial court. Any submission?
My lord, here, as per order date 8/9/2023, he was in Arunachal Pradesh, lordship. So there is possibility that he will not appear.
I will appear, my lord.
No, if we will not.
He is absconding. also. My objection on that part.
Learned counsel for the learned additional public prosecutor opposes the grant of any relief in this case to the present petitioner, as the petitioner has remained absent before the learned trial court. I have considered the submissions made by learned counsel for both the parties and peruse the materials on record. It appears that from the order sheets of the PRC case number 48/2023, which are annexed along with the criminal petition, it appears that there was nothing before the committal court to come to the conclusion that the petitioner intentionally avoiding the process, the petitioner has been intentionally avoiding the process of the processes issued by learned committal court. And further, considering the fact that the petitioner is ready to appear before the committal court and face his trial, this criminal petition is hereby disposed of with a direction to the petitioner Dharmender Gogoi to appear before the court of learned SDJMM Dhokwakhana within a period of 15 days from the date of this order, and to facilitate such appearance before the learned committal court, the standing non-bailable warrant of arrest issued against him by the committal court shall be kept in abeyance till next 1 month. With this observation, with above observation, this instant bail application is disposed of.
Diploma.
Let us see.
If otherwise it doesn't reach, my lord, then can it be taken over the last item?
Let us see.
CD, we have not.
CD is not there.
Perhaps CD will not be required, my lord. I will place my submission, my lord, if the matter is taken up. And review this as the last item.
My lord, this is the other one. This morning I,
62.
oh, 62. 62 মানে এইটো নহয় জানো, crime. কিন্তু ক'লো তো ৰাতিপুৱা। My lord, only thing is, my lord, I'll just rely on one judgment, my lord. That Air 1980 Supreme Court.
AR 19.
Air 1980 Supreme Court 1983 Issue Devi versus Union of India.
Yes, what it says.
Yes, it says, my lord, whenever there is any allegation of violation of procedural safeguards, then it is the burden of the prosecution to, my lord, disprove it. In other words, the onus is on the prosecution. It is for the petitioner to just point out. Please come to, my lord, page 6, para 5. It was in the context of, my lord, the right of a detainee. This practice has a lot of got it. Yeah? This practice marks a departure from that obtaining in England when observance of strict rule of pleading is insisted upon, even in case of application for a writ of habeas corpus. But it has been adopted by this court in view of the peculiar socio-economic condition prevailing in the country, where large masses of poor people are poor, illiterate and ignorant, and access to court is not easy on account of lack of financial resources. It would be most unreasonable to insist that petitioners should set out clearly and specifically the ground on which challenges the order of detention and make out a prima facie case in support of those grounds before a rule is issued, or to hold that detaining authority should not be held liable to do anything more than just meet the specific grounds of challenge put forward by the petitioner in the petition. So practicing in England is, my lord, even in an habeas corpus petition, the rule of pleading is insisted upon. But in our country, that is not, because of the socio-economic condition. Now, this is important. The burden of showing that detention is in accordance with the procedure established by law has always been placed by this court on detaining authority, because Article 21 of the Constitution provides in clear and explicit terms that no one shall be deprived of his life or personal liberty except in accordance with the procedure established by law. I am on this. So when, my lord, the burden of showing that detention is in accordance with law is upon the, my lord, prosecution, detaining authority on this limited part. Because I have placed the judgment in support of the other two proposition, my lord, where I have said, my lord, one, in earlier case, not in this case, 41A notice was not given, because on the day when I was arrested on 30/12/23, 409 was not added. That was the first arrest in point of time. In the present case, I was shown arrest on, my lord, 9/1. And here, of course, I will be relying upon Kamal Datta, my lord. So in support of that, I have placed this judgment.
Now, my lord, so far, section 409 is concerned, my lord. In one case, that is Gorsuk 324. In that case, I could not ascertain, because I am informed that that case there has been taken back by the investigating officer for continuing with the investigation. But in connection with Dispur PS 384.
No,
Dispur
but
PS
instant cases,
in
crime
this
branch.
case, 409 was not there.
Dispur, yes.
Dispur.
Correct.
In Dispur case, actually, he was arrested first in regards to Dispur case,
yes.
not Gorsuk.
First Dispur,
As it appears from the forwarding report, my lord, that is in today's list, item number 39. Item number
We will
39.
come to 39 later.
Later on, no, my lord, I am trying to reply your lordship's query, whether 409 was there or not. In the first time, your lordship asked me to
Yes, yes.
ascertain.
No, that query is not in
this
respect of
case.
this case.
No, I understand. In this case, it is not there. But in case where first he was
We'll
arrested.
take up that issue when we take up.
My lord, my lord. Now, so far this case is concerned, your lordship may kindly see, my lord, this is a statement of Nitul Das,
No, you
one of the.
State, what is there?
My lord, he says that he issued a.
He has,
He issued a certified copy of the sale deed, which was purportedly executed in the year 2004. And on query made by on interrogation made by the investigating officer, so why did he wanted certified copy of 2004, whether he asked at the time of putting his signature, whether he asked this question to the applicant or not, he says no. Without making any inquiry, he has issued that certified copy.
but suppose
From
somebody,
his, my lord.
Somebody applies for a certified copy.
I understand, my lord. Why, that is why, my lord, in the form of certificate copies, it is always there, for what purpose it is required.
Okay.
In the form, you will also will see, when we apply any
So
certificate copy,
his fault was.
the
n-
reason
he
has to
did not
be.
query.
given. My lord, no query was made.
Okay.
So that is implication against him.
And now
Rest I
whether,
leave to your
whether
lordship.
he is in service, the present petitioner has already retired.
No, no, I'm in service,
Oh, no,
I've been
you-
transferred from Guwahati.
Yes.
Hosai,
You are in Hojai.
presently in Hosai.
Posted as sub-registrar.
My lord.
And regarding your submission that this mandate of
Amal Dutt.
Kamal Datta was not followed. Kamal Datta, that is,
No, my lord, with all respect, I submit. My lord, it is humanly may not be possible because crime branch may not have any knowledge that similar type of case is also registered in Voronmukh PS. Only after arrest, sometimes they come to know that this person has been arrested. So immediately, it may not be possible to intimate him.
no, but that is the law. Because the mandate is that authorities of the state has to inform. So your submission is that the IO of that case may not be knowing.
May not be at the time.
Okay.
Right.
Okay, heard. Otherwise, his custodial detention is necessary.
That I cannot say not now,
Okay.
because it is prerogative of the investigating officer.
No, whether from the case diary, it appears that the custodial detention may be necessary.
No, many persons have to be yet to be arrested. Many persons are yet to be arrested, and
Other,
investigation is on.
other co-accused are yet to
And-
be arrested. and-
Yes, yes.
Okay. Heard Mr. K. N. Chaudhary, Senior Counsel for the petitioner, assisted by Mr. N. N. V. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. D. Das, Learned Additional Public Prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Ranjit Chaudhary, who has been shown arrested in the case in the crime branch PS case number 9/2023. On when were you shown arrest?
3012, my lord.
On 30/12/2023.
3012. This could be.
on-
In
on-
this case, 9, my
9/1.
lord. In this
On-
case,
this
9/1
is-
shown arrest.
On 9/1/2023.
Crime branch 9.
When he was in custody in connection with Dispur PS case number
This could PS case number, my lord,
384.
384 of 22.
384 of 22, in which he was earlier arrested on 30/12/2023. The petitioner has been detained behind the bars since 30/12/2023. That is for last, how many days?
My lord, it will be 22 days.
For last 22 days. The gist of accusation in this case is that
14 days. I think 30 তারিখ তো আজি 12 দিন না
gap
not my lord, I think it will be
44.
14 days. I'm sorry. 30 and 12 beside. 14 days, my lord. Sorry, not
For-
20.
for- in total, you are behind the bar for 14 days.
14 days.
For 14 days.
Also, আমি পুলিশ কাস্টডি আছে।
Stop.
In between, for 1 day, 2 day, I was in judicial custody. And 1 day. 1 day and rest 13 days in police custody.
Out of Out of 14
Out of
days
14 days, 1 day in judicial custody, rest in police custody.
and police custody period is over.
No, my lord. On 9th, it was given for 5 days.
You are still in police custody.
I'm still in police custody.
Okay, that means your custodial detention may be necessary.
No, my lord, no, that's a different issue. In an appropriate case, that may be a relevant consideration. But my lord, challenge which I have laid in that context, my lord, whether I am police custody or whether it is necessary, those may not be relevant in my humble submission. All that.
No, he has not been produced back from police custody.
I do not know.
He is still in police custody.
In crime branch case, yes.
He is still in police custody.
Yes. In crime branch case, but in Dispur police case, I was produced. Then my lord, permission was given. Accordingly, I was taken in, shown arrest. If my lord, if further questioning is required, I'll make myself available. Before also I did. My lord, initially I was issued a notice under 160. Once I got the bail, my lord, then my lord, everything started.
No, when last you were given on police custody, facts have to be clear.
Yes. This order is there, my lord. 1 second. 9-1. That order is at page number 42, my lord. 9-1. Page 42.
History produced on 14-1.
My lord will kindly see the only thing that the statement of that co-accused and case diary also reveals that nothing beyond. Since 9-1, that is the only progress they have made.
Till 14-1, you are on police custody.
Yes, in terms of the order of the learned trial.
This was not, this is not revealed from the police, the case diary.
No, I have not examined that point, my lord.
But case diary should reveal that in this case, whether he is on police, what statement has. Okay, I'll dictate it in chamber after going through the.
My lord.
Your submission is that in spite of the fact that he is in police custody,
Because of the procedural safeguard which has been denied to the
you are
petitioner.
pressing on that.
Otherwise, yes, ma'am, I'm entitled to bail. And in any case, my lord, that the deed based on which they're trying to,
No, if
implicate
he's
me,
on-
that they're only in possession
If
of.
he is in police custody, the interrogation part would be there in the case diary.
Yes,
9-1 entry is not there. The entry is still 4-1-24.
When the case diary was
That
received.
entry, case diary was sent to us. On 11-1.
see, my,
So 9 to 11, some,
Not 12-1.
see, my lord, this is what is going on. Very unfortunate.
okay, I'll dictate it in chamber.
Absolutely wrong procedure, my lord.
And the order of taking in police custody, to that effect, endorsement is there or not?
No, the entry is still 4-1. So question of that entry doesn't arise.
Okay, it is
Because that order
updated,
was passed on 9-1.
it is updated till 4-1 only. So supplementary case diary must have been there.
No, my lord, I
Because-
do not know whether any supplementary case there. No, this is the case there because it was sent to us on 12-1.
So where
On being
the,
called for, we sent message
So-
and it was sent to us.
so where they are interrogating, where they are making the endorsement.
My lord, that's why I said, my lord, in the other two cases, we have annexed this had notice under 160. Once we got interim bail, my lord, then everything started moving.
Black corridor. Okay, I'll go through it.
Item number 39, my lord. Same thing, same case, same facts.
Item number 39 is a different case.
Different
This
case,
poor-
but the same petitioner.
This poor PS 384.
Same petitioner.
Application
In connection with
statement.
which, my lord, he was first arrested.
As same Nitul Das made that statement, that's why, my lord, I was arrested.
And in item number 35, you are not on not in police custody.
So no, I was, for 9 days, I was in police
In
custody.
that case, you have not been.
Now I have been, naturally, since I have been taken into custody
Only in this case.
now, with effect from 9th.
Okay.
39 will be taken up later on. Other bill, some more.
You have any submit?
My lord.
Same
some-
thing, my lord,
No,
same
no.
principle. In fact, another additional point is that 409 was added subsequently. On that date, when I was arrested on 30/12, my lord, I was entitled to that notice, which was not given.
On 39, you have any submissions? Mr. Das.
No, that is there, but at the time of his arrest, 409 was not there.
So their
So that is,
submission
he
is
is
that,
correct on that point.
their submission is
that
that
is why
Anil
41
Kumar notice was not.
Not given.
Okay. Okay, both I will
Well,
pass orders in
My lord.
general
Deeply.
after going through the case diary.
My lord.
Yeah, my lord, this, so far, this case is concerned, my lord, criminal, crime branch number 9 of, my lord, 23. There is another matter, another petition, that is item number 36. Actually, the case diary came in connection with this case. It is not his case. So, my lord, I will hand over the case diary after 36 is over, my lord.
Okay. আমি কিমান items চলি আছে এতিয়া? So who is the counsel for 36, item number 36?
36, the council is not.
Let us take up 36 also.
তুমি আছো নেকি?
Malad, matter of time being, Malad, Mr. AM Bora will submit.
Okay.
I can hand over the case date of 39, item number 39. His case, Mr. Sudhir's case. Same, Ranjit Chaudhary, same petition.
Earlier case, this could be a case.
Yes. This would be-
39, you are ready?
My lord.
39,
36 and
36.
35.
35.
No, we are not taking 35 now. We are taking only
36.
36.
36.
Both are not same cases.
Yes, but they're not same cases, buddy. 36, my lord, the same principle, the Buddha's principle is applicable.
No, 36 PS case, no, দুটা case আহিছে সেইকাৰণে 36 কি হ'ব। 36 to
35, we
একেটা
will call
case diary. One case diary, two petitions.
the case which is related to this.
Case diary আছে।
We are taking up
36, my lord.
36.
Yes, my lord.
এই 39 to
Baharul Islam Khan.
Yes, my lord. I am the lawyer, my lord. Here,
Baharul Islam is a lawyer.
my lord.
lawyer.
His allegation that he has forged the document, whereas the document pertaining to 1997, the alleged document, my lord, which has been executed in 31/12/1997, my lord. Alleged forged document.
Setia,
When were you arrested?
39.
I have been arrested, my lord. Wait to go. No, no. First. 15.
অংশ কোনটো কৰি আছে এতিয়া? 36 to
36.
36.
15 December.
15th. 18 holo ji. Today is, my lord,
15 December or November?
28 days, my lord, today.
Yes, what is your submission?
My lord, in this case, my lord, the alleged forged the deed, my lord, between the parties executed 31/12/1997, my lord. Sale deed, my lord.
In the forwarding allegation is that I have prepared that forged sale deed. Page 10, madam.
Yes.
What you can see in the bottom, my lord, grounds of arrest, my lord.
Yes.
The below named accused person, one of the members of the organized crime, he along with the other co-accused creating the failed sale deed number 6832 dated 31/12/1997, madam.
Yes.
Well, at that time, I have now subsequently, my lord, page 27, lordship kindly see, there is a title suit by the same informant, page 12.
Which,
And whereas this case, I have been entrusted by the client, my lord, to conduct this particular case, my lord. Challenging the same sale deed,
where is the title suit?
the title suit starts from, my lord, page 12. Jogeshwar Nath,
Okay.
Mukshid Ali. So they have challenged this
In this
particular.
case, someone got bail yesterday also.
Yes,
Oxid Ali Jogeshwar Nath.
Jogesh Nath or something like that. Jogendra Nath.
Now, my case is that, my lord, though there is an allegation of forgery against me, my lord, but I have entrusted to conduct this particular title suit on behalf of the defendant, my lord. So, in my possession, this copy of this sale deed has been recovered. Whereas, my lord, I have enrolled as an advocate in page 43, my lord, lordship.
Oh,
kindly
your
see.
submission is that the copy of the sale deed was given to you by your clients.
Yes,
For conducting the civil suit.
my lord.
Okay.
And the Okalatama also, whereas I became a lawyer in 2008 only. Whereas that particular title sale deed was executed in 1997, my lord. 26 years now.
Now, what is the allegation against you in this case?
That I have prepared that.
You have forged the sale.
Forced this sale. FIR I have been not named. Subsequently, I have been arrested on the suspicion. And
No,
the
sale deed is purported to be of 1997.
1997. Admittedly,
Okay, but when it was actually,
that I don't know, my lord, actually.
because allegation is
Yes.
that this is a forged
Forced
sale.
sale deed I have also prepared in 1997 because it was recovered, the photocopy was recovered in my possession.
Okay. So your submission, yes. What else?
That's, my lord, it can't be, my lord. I can't be a party to the forced sale deed, my lord.
And you are an engaged lawyer in
Yes.
title suit 51
Yes,
to show that what is the Wakalatnama is there.
Okalatnama is page 32.
Wakalatnama submitted before the civil court.
B.I. Khan, my lord.
Okay.
That is 2022, my lord. Probably my custodial detention also not required, my lord. I have already 28 days. Everything has been recovered and
What materials are there, Mr. Das?
and the main
Materials,
accused has been enlargement yesterday, my lord.
materials are there. There are two advocates involved in such type of incidents.
One
Moinul
Moinul,
Haq and this one.
whether Moinul got bail or not.
No, till now.
Moinul is in custody.
Yes.
In this case,
No.
not in this case, my lord.
In this case, Moinul is not
Moinul
involved.
is yet to be released from bail.
No, in this case, whether Moinul is involved.
No, whether Moinul,
No, there is no Moinul Khan.
The only present petitioner is the lawyer.
Yes,
my submission is this. So far material is concerned against him. Materials are there. only the length of detention. Whether his further, my lord, detention is required or not.
This CD you are giving along with the earlier case argued by Mr. Ken Chaudhary. Same case.
Yes, exactly.
Same case
Yes,
there,
yes.
no?
Yes.
Give that to me in
Hey.
chamber. I'll dictate the order in chamber, Mr. Bora.
Yeah.
Because I have reserved another connected bail application. Today I'll dictate it in the chamber after going.
The other petition also Lordship can take up. The 35, this is the same law point involved, that's why I'm saying. Because in this case, my lord, when I was arrested, I have been shown arrest in this case, my lord. I have been not named, nowhere, nothing is involvement here. Only been shown arrested without intimating, my lord, that this case is pending against me, my lord.
So you are also relying on which?
Yes, these are the judgment, my lord, because that's the mandatory provision, my lord. Uday Chan and the Kamal Datta's case is squarely covered this case also, because I have been not intimated regarding the pendency of this particular case when I am initially arrested in the first case, my lord.
Case diary is available in this.
Available.
Whereas in
Similar type of allegation will, he is lawyer. Should I hand over the case?
Yes. Okay, I'll go through the case diary.
And in this case, I am already 28 days in custody. Sorry, madam, 23 days, madam. Earlier it was 28, this is 23 days.
When were you arrested in this case?
In main case, I was arrested on 15/12,
And in this case?
2012. Shown arrest.
Tinita ভিতর দিছে না? Okay.
Citations are not required, my lord.
Same Uday Chan and, okay, that is
There-
there.
There are other two cases, my lord, in the Guwahati High Court, similar, my lord. I am not placing, same matter. Based on the Uday Chan's case, my lord. Previous to the Kamal case, my lord. There are two other cases also.
No, you place that if there are
Right
cases.
now, I don't have, my lord. Same perimeter, my lord, same squarely covers that it has to be informed, my lord, to the person concerned. That's the law. So that he can go for anticipatory bail. That's right has to be given, my lord. That
The
is the concern, because it's a
Purpose is that.
purpose is that, so that I can avail the legal opportunity, my lord, whatever, if I desire.
Okay.
Because it's
That has been explained in some judgment. What is the purpose?
not
Or
directly.
that is the submission.
That is my submission, that why this is required, my lord,
Yes.
so that I can take the benefit of the legal remedies,
Recourse.
my lord. So that when one case is, because they have so that I can go for an anticipatory bail in the other cases. That's so that otherwise I have no knowledge about it. So this can continue for the one after another. I'll be the remedy list, my lord. I'll be in the custody. I cannot go for anticipatory bail.
Okay.
So considering the Article 21, that is the mandate, my lord.
Okay.
That's all.
Yes.
So main accused is already on bail, my lord, in the item first one, my lord.
No, yes, that is within my knowledge.
Yes, ma'am.
May I please, your lordship, 438 application, my lord. My lord, FIR case 8, my lord. In this case, my lord, only on suspicion, my lord, against 3 persons, my lord, this FIR was lost, my lord. Number 1, my lord, Tofikur Rahman. Number 2, Akhtul Ali. Number 3, Azmul Ali. And my lord, I am on behalf of Akhtul Ali, my lord, accused number 2, my lord. And accused on behalf of accused number 1, my lord, the arrest bail application was, my lord, preferred, my lord. And in that case, my lord, your lordship protected him, my lord. Right, an interim order, my lord. I have annexed the order, my lord. Kindly turn to page, my lord, 15, my lord, 15 and 16. That is also pending, my lord. Next date is, my lord, 29/1. Page 15 and 16. So similar relief, my lord, I am taking. Relief, my lord, I am taking.
Yes, and the co-accused has been protected.
My lord,
Let the case diary be called for. Let him appear
my lord.
in.
My
Yeah,
lord, that is
in the
AB number
courtroom.
3914.
AB case number 3914/2023. Same facts, same submissions. Name of the lawyer is Learned Counsel, Mr. S.H. Sikdar. And the heard Mr. S.H. Sikdar, Learned Counsel for the petitioner. Also heard Mr. K.K. Das, Learned Additional Public Prosecutor. Remaining submissions same. And you appear before the IO within 10 days.
My lord,
If you do so, you are allowed to go on interim anticipatory
yes, my
bail
lord,
of
I will appear, my lord.
30,000 with one surety of like amount. Next date is 18/12,
Next date is from 29/1.
29/1,
It was extended later on, my lord.
29/1.
Yes, my lord.
Exit to the office.
এটা 29 আছে আগে extension
29.
29 আছে
29 January.
my lord. I love this man.
Ma'am, Lordship. Lordship, application 438, Lordship. The allegation 366, Lordship. The FIR is piece 12, Lordship. Lordship, can find out piece 12, Lordship. Lordship, here in this case, Lordship, the FIR lost in the year of 2020, Lordship. And Lordship, after that, the both party has mutual Lordship. The petitioner is a love and affection, Lordship. Piece 20, Lordship. Is clear, Lordship, I'm sorry. And the one female child also have Lordship, the 3 years. 3
No.
years old Lordship. It's a love and affection Lordship. It's not a.
Now, where is the
360.
victim now?
Victim may already married sir, with the petitioner Lordship.
Oh, you have married the victim?
Yes, Lordship. And agreed the both family.
Okay.
member, Lordship.
Where is that statement in the bail
So I have stated in
application?
para number 7, Lordship.
Heard Mr. R.C. Das,
RC Das.
Learned Counsel for the petitioner. Also heard Mr. K.K. Das, Learned Additional Public Prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Abu Bakr Siddiq, who is apprehending his arrest in connection with Kosua PS case number 39/2020 under section 366. The investigation is still pending.
Lordship, charge sheeted, Lordship.
Charge sheet.
Trial is going on, Lordship.
You
Charge sheeted,
are
Lordship. Charge sheeted on 7/2/2020, Lordship. Charge sheeted.
charge sheeted case.
Yes, Lordship.
You have not received summons.
I have received some. Yes, Lordship. The few months ago, I have received some, Lordship.
Then you have not appeared.
Not different, Lordship.
You appear before the trial court.
So I may allow to appear so with a condition, Lordship. As
What
because Lordship-
condition?
Any condition, Lordship, the bail. And
The
loss of bail.
condition is you appear and move bail there. Because in 366, the trial court may grant you bail. The committal court has,
So Lordship,
What
Lordship,
is-
one AB was rejected by the subordinate court. Lordship.
AB was rejected
Yes, Lordship, but not regular bail, Lordship.
because you are not appearing before the trial court.
Yes, Lordship. Someone received Lordship last month, Lordship. I have received someone, Lordship.
Then where is the apprehension?
So someone received, Lordship.
No, Mr. Das,
Yes,
if
Lord.
you have received summons, where is the apprehension that you may not be allowed to go on bail? What is the maximum punishment in 366?
Yes, Lordship.
What is the maximum punishment?
It's 10 years, Lordship.
So the committal court may grant you bail.
So the JMC, the session just, Lordship. And the JMC has not permitted the grant of bail, Lordship. The judicial magistrate first class and Nagaon, Lordship. The session, I have applied before the session court, Lordship. Session court has rejected the AB.
it has rightly rejected because the committal court may grant you bail if you appear
Before the trial court.
before the committal court. It is pending before the committal court only. You appear before the committal court and pray for bail there.
So
কি
if-
লিখে নাও? Stop. Under section 366 of the Indian Penal Code. It appears learned counsel for the petitioner has submitted that in Kosua PS case number 339/2020, the investigating officer has laid the charge sheet and the petitioner has received summons. Where is the copy of?
Lordship, Lordship, I have someone received on 2/7/2021, Lordship. I'm sorry, Lordship, the wrong is the 2021 I have received the summon, Lordship. But thereafter,
Someone issued it.
No, facts have to be clear at least.
Lordship, the fact is here, Lordship. So FIR registered in the year 2020, Lordship. So thereafter, Lordship, the both family has mutually agreed, Lordship. So the police did not investigation. Subsequently, Lordship, investigation and summon received by the subordinate court, Lordship. After submitted the
When have you received summons?
someone received, Lordship, the 2/7/2021, Lordship.
Thereafter, what happened?
Thereafter, Lordship,
Thereafter, what happened?
so Lordship, thereafter the COVID.
We are fixing
COVID
this case after vacation. You come prepared.
Lordship, thereafter the COVID situation was there, Lordship.
After
Therefore,
21, there is no COVID.
Lordship, during the 2020.
Mr. Das, you are not prepared with the case.
Lordship, what happened here in this case, Lordship? So
You-
the
You come prepared. We are fixing it. Otherwise, I will dismiss it.
Lordship, fixed after vacation, Lordship.
Yes.
Yeah,
Heard on request of learned counsel for the petitioner, let this case be listed again on. When do you want it?
Lordship,
You come prepared at least
yes,
with
Lordship,
facts.
yes.
When do you want it?
Lordship, very short date of after vacation, Lordship.
Give a date.
20, Lordship.
20 is holiday.
Also 10/21, Lordship.
21 is holiday.
Holiday, yes. I'm sorry, Lordship. Yes. 22, Lordship, is a Monday, Lordship. Yes.
Release this case on 22nd January.
I'm sorry for that.
Okay.
Much obliged, Lordship.
Item 17. May please, Your Lordship. So this is 438 application, Lordship. FIR is at page 7, Lordship.
Yes.
There the allegation that Lordship, the fellow of the petitioner side, Lordship, enter into the paddy field of the informant, Lordship, and damaged their paddy field, and thereafter they came to the informant and.
But grievous assault, injury of the victim on head and face is reported.
Here in this case, Lordship, what happened after that, Lordship, the father of the informant, Lordship, along with some person came to the came to the father of the petitioner to complain about the damage of the paddy field. And some person who came along with the father of the informant, Lordship, demanded money 30,000 for the damage of the paddy field, and there are some quarrel between them, Lordship. And in that process, Lordship, it is the informant side who assaulted the petitioner, Lordship, with dao and lathi, Lordship. And petitioner caused minor injury, Lordship. And they came with a deadly weapons, not the informant side assaulted.
No, but allegation is against you.
Lordship, yes, Lordship, allegation is against me, Lordship. The allegation is under section 326, Lordship, and 307. And he approached the Lordship, 24. He approached the trial court, Lordship, and the trial court rejected our bail petition. Like, kindly for a moment, come to the page 13, Lordship. Yes, the observation is that the father of the informant sustained some injury, but nowhere it is mentioned that he sustained grievous injury or any cut injury on his person, Lordship. Page 14, Lordship, relevant.
No injuries on
Head
head,
and face,
face.
Lordship. But
Now we have to peruse the case diary,
In the meantime, some protection.
not now.
Here,
Heard
had
Mr.
there been any grievous injuries there, they would have mentioned here.
It would have been reflected. That is your submission.
The simple, no cut injury.
Let us see. Heard Mr. B. Haldar, learned counsel for the petitioner, also heard Mr. K. K. Das. Considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary.
24.
Short day.
24, fixing 24-1 for case diary.
Yeah, please, Your Lordship. My lord, in this case, my lord, complaint case has been initiated against me, my lord, under 156(3), my lord. Lordship kindly see the complaint case is page 16. And the Lordship kindly see here, the wife has filed the complaint against me. Page 16.
Yes.
Sonam Nayak, aged 29 years, wife of Pratap Sena. I am the Pratap Sena here now. So, my lord, both are the police constable. They are having the love affairs, my lord, for a
The
considerable.
complainant is also police constable.
Yes. Both.
Your wife is also police constable. Okay.
She has filed the case, my lord. The complaint case, basic allegation is the miscarriage of their child, my lord.
And bigamy also.
Bigamy also, that I was previously married. So that's the bailable offense, Lordship knows it. And the basic allegation is that I have taken her to a hospital and we caused miscarriage, my lord.
313.
313.
Okay.
And this complaint is, apart from that, my lord, this complaint is not maintainable because of the fact this is not supported by any affidavit which is required, or there is no avertment to the effect that the prior.
Now in this complaint,
Yes,
the court has taken cognizance.
court has registered it, court has forwarded it, my lord, as a FIR.
Oh, on the basis of this complaint and
It is under 156(3), my lord.
a PS case has also been registered.
Yes, on the basis of this. So it is under 156(3). And Lordship knows there is a judgment of the Supreme Court as well as our High Court. Under 156(3), before forwarding it, there has to be supported by an affidavit and there has to be an avertment to the effect that she has earlier approached the police. If the police has not registered the case, then only she can come under 156(3), which is not here, madam. The Lordship can only see the complaint not supported by an affidavit and there is no avertment to that effect that earlier to this filing of the complaint under 156(3), she has approached the police and they have refused to register the case. As such, she has approached under 156(3). So this, otherwise also this complaint is not maintainable. And apart from that, in the factual background, my lord, the admittedly both have cohabited for a long time. And there is a delay in the filing the whole case also. So I pray for an interim protection, madam. The judgment of Supreme Court also, Lordship knows, Priyanka Srivastava.
What it says?
It says they, under 156(3), there has to be supported by an affidavit.
No, but whether the affidavit is there or not.
That apparent from the here, and apart from that, there has to be specific avertment that she has or anybody has approached the police prior to filing of the complaint under section 156(3). That's a settled proposition of law, ma'am.
But is that the basis on which you are praying for anticipatory bail?
Because the whole complaint is not maintainable, but I am apprehending as they have registered it.
Apart from that,
But yeah, apart from that, the allegation against the husband, that's, and the delay, both have resided together. And the rest of the allegation, the Lordship can, she has said, one way she has said she has
Now where she stay now?
Both together, then.
Now.
My lord, first love, thereafter, my lord, marriage solemnized. Both of them, my lord, cohabited. Thereafter, my lord, allegation of miscarriage. And thereafter, your lordship may kindly come to page 5, paragraph 14. That the complaint begs to submit that on
He
29.
again married.
Yes, my lord. Thereafter, because my lord, his earlier wife along with children, my lord, entered into his quarter, and thereafter, my lord, entire problem arises. And by suppressing that fact, my lord, he married the present victim, my lord.
What is your submission?
My submission is that, my lord, at this stage, Treasury may be confused. Oh, I will,
Let him appear.
yes.
Third, Mr. A. M. Bora, learned senior counsel for the petitioner, assisted by Mr. B. Bora, learned counsel for the petitioner. Also heard Mr. P. Borthakur, learned additional public prosecutor. This application under section 438 of Code of Criminal Procedure, 1973, has been filed by the petitioner Pratap Senar, who is apprehending his arrest in connection with Silchar PS case number 2470/2023, registered under section 312/313/417/494/495/498A of the Indian Penal Code. The gist of accusation in this case is that one, Sonam Nath, who is the wife of the present petitioner, had lodged a complaint case which was registered as complaint case number CR case number 571/2023 before the Court of Chief Judicial Magistrate Kachar, inter alia, alleging that the present petitioner with whom the complainant got married with whom the complainant got married on 17/6/2023 had subjected the complainant to cruelty after the said marriage. It is also alleged that the present petitioner was married before his marriage to the complainant of the said complaint case to another woman with whom he had 2 children. It is also alleged that where is the miscarriage allegation? During the subsistence of his marriage between the complainant, the petitioner also had administered some medicines to the complainant and caused miscarriage to her in the month of August 2023. Learned counsel for the petitioner has submitted that. Where is the case that which you were referring to? Learned counsel for the petitioner has submitted that. Senior counsel for the petitioner has submitted that the complaint case filed by the complainant Pratap Senar the complaint petition filed by the Pratap Senar is not supported by an affidavit
And an advertisement.
and an averment to the effect that before lodging that said complaint, she had approached police. However, the said complaint had been forwarded by learned Chief Judicial Magistrate Kachar under section 156(3) of clause 3 of CRPC to the officer in charge of Silchar Police Station to register an FIR on the basis of said complaint, which according to present petitioner is not the mandate of law, which according to learned counsel for the present petitioner is not the mandate of the law. Learned counsel for the petitioner has also submitted that the petitioner and the complainant had stayed together all along for how many days?
Maybe my lord, 2 months or more.
For 2 months, and he is, what else is your submission?
It is on the basis of the concept, my lord, this is abortion.
Yeah, otherwise, my lord, one paragraph 16, earlier the present petitioner has made in the complaint petition, my lord, an application before the SP Kasar, my lord. Paragraph 16, my lord, page 6.
Learned counsel for the complainant has also submitted that the petitioner has that the petitioner would cooperate in the investigation if he is allowed to go on bail. On the other hand, learned additional public prosecutor submits that there are materials against the present petitioner from the learned additional public prosecutor submits that perusal of the case diary would be necessary for consideration of the instant bail application, hence call for the case diary. However, considering the facts and circumstances of this case, the petitioner is directed to appear before the in the meanwhile, petitioner is directed to appear before the investigating officer of Silchar PS case number 2470/2023 within a period of 10 days from the date of this order and cooperate in investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with Silchar PS case number 2470/2023, he shall be allowed to go on interim anticipating bail of rupees 30,000 with one surety of like amount subject to the satisfaction of the arresting authority. Let this case be listed again
On 13-2.
13-2 for case then.
Like only just last paragraph, I have marked it in the judgment requirement of the 156(3). I have also marked. Only last part of the.
Paragraph learned counsel for the petitioner, senior counsel for the petitioner has also relied on a judgment by this court in 1540 in Tarun Dev Sharma versus State of Assam, reported in 2015 JLT 413, wherein it was observed as follows. Court paragraph marked in red pen. Okay. This is the of course.
FIR is page 9, but there is a clause FIR money. I mean, mutual market was took place and both sides are got injured, has been injured. And our side also my lord sustained injury my lord. PS 9 my lord is the FIR.
What injury?
Injury, my lord, as per their FIR, my lord, injury in the stomach, my lord. But to my information, my lord, only simple cut injury, sustained simple cut injury. And in the cross FIR, my lord, they are the informant is the aggressor, my lord. And in this case, my lord, our two person is sustained injury, grievous injury, my lord. One Fakhruddin and one Rafiqul Islam.
Yes, myself.
Otherwise, my lord, assaulted my lord over head and causing my lord serious injury, my lord. And now the present two my lord injured persons, Suruz Ali and Minara Begum, are undergoing treatment at GMCS. My lord. That is the
Injury report,
This is the only make out the case, my lord. Rather, my lord, they are admitted in the Nagaon Civil Hospital, and after given the first aid, my lord, they are released from that. This is the our side, not the injured person, my lord. Seriously injured, my lord. They are the aggressor, and they constructed a CIC on the bank of the fishery, my lord. On our fishery, my lord. When the petitioners are went to the dismantle the shed, my lord, there is a market. my lord.
there is no specific allegation against my lord, the accused person, but against all the accused persons that they my lord assaulted the present victim as persons, my lord, and now they are undergoing treatment. My lord.
yes, very.
Actually, in the meantime, some protection, my lord. Petitioner number one is the teacher, my lord. One is the teacher, and petitioner number 5 is his resident is 15 to 12 kilometer distance, my lord. I am specifically mentioned, my lord, para 2 notes.
Petitioner number?
One is the teacher, my lord, of LP school, my lord. And para 2, my lord.
Very clear, better.
And petition number 5 is the nephew whose residence is 12 kilometer distance from the place of occurrence.
Against whom the allegation is made?
There is no
Against
specific
all the,
allegation.
against all the accused persons.
All the
There is no specific allegation.
Who assaulted, there is no specific.
No,
matter.
therefore, case diary would be.
Yes, ma'am.
At best, we can do one thing. The women petitioners may be granted.
Yes,
protections.
but
That benefit you can avail. Otherwise,
otherwise,
two women petitioners are there.
No, my lord, there is no any woman.
no.
There is
No woman
no,
petitioner.
my lord.
No, I can,
Petition number one.
or I can produce the case diary on 25th of
Heard
January.
Mr. A.M. Ahmed, learned counsel for the petitioner. Also heard Mr. C. Borthakur, learned additional public prosecutor. Considering the nature of allegation leveled in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary. Fixing
On my lord, 25-1.
25-1 for case diary.
My lord, at least petitioner number 1, my lord. He is the teacher,
No.
my lord, of a school.
No, merely teacher will not suffice. Some other,
Actually, my lord, what happened, my lord, in this informant is the aggressors, my lord. They constructed CIC on the bank of the fishery of the petitioners, my lord.
let us peruse the case diary.
That is the-
25-1.
May it please your lordship. An application under section 438. Here the petitioner is a ailing 80-year-old person who is a proprietor of a farm in Delhi known as Messrs Arya Bag Industry. Kindly peruse to page number 14, that is the FIR. Now, why the petitioner is having an apprehension is because of the fact that this FIR, which has been lodged by the informant who happens to be the Assistant Commissioner of Tax, has informed the Special Task Force on 3rd of January regarding that there were some consignments have come from Delhi to Guwahati in 2 wagons, where there were some few number of 341 numbers of packets of gutka, jorda, and pan masala were seized, and which were, according to the Assistant Commissioner of Tax, they did not have the proper documentation, and that those particular wagons were actually carrying those jorda, this pan masala and gutka in the name of some textile. That is the part of the allegations that has been alleged by the informant in the FIR.
In the name of some?
But there were 2 persons in the name of Uday Chand, Uday Charasia, and then one Subodh Singh, who happens to be a transporter. Now here, the petitioner, he is not FIR name, but still he is apprehending that there might be some coercive action taken by the police against him, because kindly peruse to page number 35. That is the 41A notice, my lord. So what has happened is this, while the investigation was going on, maybe the police, the special task force have come across some materials and they have issued 141A notice to the petitioner who happens to be there in Delhi. Now this petitioner, he is not at all involved in any of these particular allegations that has been alleged in the FIR. Now, why is he presuming that that he might be arrested? Because of the fact that there were few invoices that were mentioned in the 41A notice, and those invoices were submitted by SR Transport, and that particular SR Transport has said that the consignor is that from Mercer's Arya Bag Industry. But this petitioner, he's a very small businessman there, and he's mainly involved with some manufacture of some plastic cane, chair cane, sutli and brooms. So he's not at all involved. Now what has happened is that once this petitioner, when he has come to know about this notice, he had gone to his industry, his office, and he has inquired about if something has been done from his end. And he has come to know that there might be some forgery that might have taken place in the name of his proprietorship firm, and his seal and his stamp could be misused, and for that he had already informed the station house officer of that local jurisdictional police station. That is in page number 36, my lord. He has already written that particular letter intimating about his receiving of the 41A notice. And now, my lord, now since he is already a ailing person, he is having deformity of bones, he is having a poor vision, he is an old man, he is involved with some petty business from Delhi, might have carried some business, but he's not at all involved in this particular allegations, which has been leveled in the 41A notice also, regarding few invoices numbers, which he had submitted.
No, according to 41A notice, whether you have approached the IO.
Yes, my lord. Already there are, he has already telephoned the IO. Now, since he is ailing there, kindly peruse to page number 40, that is the medical document. He has been already advised by the undergoing doctor there that he should be under rest, and at any moment of time, anything can happen because he is having a very poor vision. Second, he is having deformity of bones and lot of other ailments, my lord. That is in page number 40, that is his medical certificate. Now, my only humble prayer is that since he is an old person, my lord, and his name has been just implicated because of the fact that that particular invoices had the bearing of that particular name of the seal of his industry, but he has not involved, and he has already informed that to the local house, to the station house officer of the local police also. Now, if let the CTP call to get into all the materials are there or not. In the meantime, I may be protected, my lord. I am already telephoned the IO, and already I am going to cooperate. Only fact that since I am a senior citizen and I having very bad health, so looking into that condition, may I be in in interim?
Will you be able to appear before the IO?
Yes, I at least once I get fully recovered, and then I will come. And now, since I am under the medical supervision.
When you will.
My lord, that given the fact that since he is under medical supervision, at least some amount of time.
Now I want to know about your state of
My lord, at least from Delhi, if I have to come, I need to get the certificate again regarding whether I will be able to come down. But I have already telephoned the IO, and I've already informed, and whatever was required.
No, suppose we allow your interim prayer.
Yes, my lord.
And if we impose
1 month, my lord. 30 days.
within 30 days, you will be a healthy person.
That is an assumption that I could be recovered at that point of time.
Let him appear.
Yes.
W.R.
Medhi.
W.R. Medhi, learned counsel for the petitioner. Also heard Mr. P. Borthakur, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Satinder Pal Bhatia, who is aged about 80 years and who is apprehending his arrest in STFPS case number 10/2023 under section 120B/420/468/409/403/109 of the Indian Penal Code. The gist of accusation in this case is that on 3rd August 2023, one Vidyut Jyoti Kolita, Assistant Commissioner of State Taxes, Guwahati, lodged an FIR before the officer in charge of Special Task Force Police Station, comma, inter alia, comma, alleging that and on receipt of an information through reliable sources that on 1st of August 2020, that so- that huge consignment of gutka, comma, pan masala, comma, jarda, etc. are being carried in wagon numbers 1029 slash and 60788 of train number L slash ends L slash number 5. Which train it is?
My lord, the train, the name of the train is not properly mentioned, but the train number is there. Train number is there.
Within bracket 43 BCN. Close BCN mixed bracket close from Delhi to Guwahati. It is alleged that the said consignment has been sent by some businessmen to avoid taxes, by avoiding taxes, which and what other allegation is there? Avoiding taxes and by putting government at loss by paying less taxes. Stop. Accordingly, 341 numbers of gutka, comma, zarda, comma, pan masala, etc. was seized from the said wagons at Ajara railway station during verification process of the and during verification process, names of two persons, namely Uday Chaurasia and Subodh Singh, came to the light. In having been involved in the illegal activities. Stop. Learned counsel for the petitioner has submitted that though the present petitioner has not been named in the FIR and he is having a
Apprehension.
what business you are having in Delhi?
I'm basically involved with manufacture of polythenes, which is in the manner of manufacture of cane, this bamboo cane. Packaging material, plastic, dealing in plastic chair cane and packaging material, Pua plastic, Sutli and Broom.
Having business in packaging materials at Delhi. Learned counsel for the petitioner has submitted that the petitioner is an old and ailing person. However, is an ailing and old person of 80 years of age. However, on 12/12/21, he received a notice from the investigating officer of the instant case under section 41A of the CRPC, wherein mention of certain invoices has been made. How these invoices are related to you?
These invoices which have been mentioned in 41A notice, these invoices does not match with any of the invoices which this particular petitioner has there in his industry, because this petitioner is maintaining his record book from the month of this month July till August, And as per the chartered accountant, in a inquiry which he had done through his own source, he has found that it is in
What is the last
sequence, my lord, and there is no breakage of the sequence.
mention? And it has been mentioned that the present petitioner is the consigner of 170 numbers of plastic bags.
Alleged, ma'am.
According to him, my lord, those invoices were misused
Misuse.
of his fund.
170 numbers of plastic bags which were recovered from the aforementioned wagoner. Learned counsel for the petitioner has submitted that the invoices mentioned in 41A notice received by him does not tally with any of the consignment connected with his business.
Yes, ma'am.
And in this, and therefore he suspected that some forgery
Yes.
has been committed.
Yes.
And accordingly, on 24/12/2023, he informed the SHO of Bada Hindu,
P.S. Bada Hindu Rao.
PS Bada Hindu Rao at
Delhi.
Nawabganj Pul, Bangash,
Delhi.
Delhi. Stop. Learned counsel for the petitioner has submitted that the petitioner is no way involved in the offense alleged in the FIR, and as he is an ailing person. Where is the medical report?
That is annexure E Golly, my lord, page number 40.
Ailing person suffering from multiple joint pains with deformity of feet bones, and along with poor vision and not in an immediate position to visit Guwahati. However, as the 41A notice has mentioned that the invoices mentioned therein are alleged to be in respect of the consignment sent allegedly by him.
Yes.
Therefore, he is apprehending his arrest in connection with this case. The petitioner has, learned counsel for the petitioner has submitted that considering his health condition, he may be given some time to appear before the investigating officer, and he is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor submits that perusal of the case diary would be necessary. for-
Yes, only considering his old age and medical ailment, and regarding, and also considering his reply of section 41 notice.
Hence, call for the case diary. Learned counsel for the learned additional public prosecutor also.
Otherwise, my lord, my objection may be recorded.
No, I am not mentioning anything.
Yes, yes.
Stop. Fix, call for the case diary fixing.
On my lord, already 1 month time, your lordship, then my lord, on 28th of February. my lord.
Fixing 28th February for case diary. In the meanwhile, the learned counsel for the petitioner has submitted that the petitioner, as learned counsel for the petitioner has submitted that the petitioner would be able to appear before the investigating officer if 1 month time is given to him. He is hereby directed, the above named petitioner is hereby directed to appear before the investigating officer of STFPS case number 10/2023 within a period of 30 days.
Subject to his medical health.
No, you take time, but try to, how much time?
Then, my lord, 1 month, I don't think so that it will be, because he's already in hospital. This,
Then you come to this court again.
my lord, 45 days. My lord, 45 days, and then because I am taking it a bit for the petitioner, because without his instruction, I am submitting. 45 days.
Let it be 45 days.
On March first week. March 10th.
hereby
Looking at it, yes.
directed to appear before the within 45 days
Okay.
from the date of this order and cooperate in the investigation. And if he does so within the stipulated period of time, in the event of his arrest in connection with STFPS case number 10/2023, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Condition number 3, the petitioner shall, however, cooperate with the investigating officer through, and if required, through other
Yes,
electronic mode,
Absolutely.
like video conferencing
Yes, ma'am.
or telephonic mode.
Thank you.
Let this case be listed again on
13-3,
13/3 for case diary.
Obliged.
Right, Your Lordship. Lordship, this is a 438 bail application. Petitioner is a regular employee of APDCL, Lordship. What has happened? Petitioner did a massive disconnection of electricity and anti-theft drive by an order dated 15/12/23 by Mankasa Electrical Subdivision, Lordship, where informant misbehaved and verbally abused the petitioner on duty, Lordship. And there's a cost case also. South Salmara PS case 360/2023, Lordship. The
No,
petitioner,
who misbehaved with whom?
the informant himself, Lordship.
Informant misbehaved with you.
Yes, Lordship. I was on duty. I was doing my duty.
What is the allegation against you?
Present affair is page 8 mil.
Yes.
Yes.
I didn't receive any money, Lordship, from the informant.
You have received money from the consumers and have not deposited it.
Yes, that is.
That is the allegation.
That is the.
Yes,
Is
Lordship, it is an allegation only. There is no proof, Lordship.
Maybe,
Otherwise,
what
why-
allegation is made, my lord. Nowadays, your lordship already knows that all maximum, my lord, the current bill, my lord, they paid by online. And here, my lord, I have no any authority, my lord, to collect any money, my lord. I am an employee, my lord, of the board, my lord. And board was given me, my lord, duty to disconnect the theft of electricity. And I was, my lord, following the duty of the official duty, my lord, doing.
No, that is not the allegation.
Allegation is I have taken money.
On
is
that
the-
you have to make submission.
Yes, well,
On that problem, I have not taken any money, number one. Number two, there is no authority, I have no authority also, my lord, to collect any money from any person, my lord, any customer, consumer, my lord. And moreover, my lord, I have no any, there is no any proof that I have received money. And from whom I have received money, they have should mention.
There is a cross affair also.
Yes, cross filed by the, my lord, by authority, my lord.
Where?
Regarding, my lord, the theft of, my lord, electricity,
Page
except two, my lord,
Page 14 mil.
page 13, 14 years, my lord. Married, my lord.
No, no.
Allegation is there, he is, my lord. With reference to the subject cited above, I have the honor to inform you that on 2012-2020, myself along with three Shahinur Alam, SMR and Riazul Islam.
Mirazul.
I am Riazul Islam. Where do you connecting, my lord? This kind of, we are.
Your name is
Riazul Islam, my lord.
Mirazul or Riazul?
Riazul.
Hello, here in the cross affair, it is stated as Riazul Islam, and
Yes.
here in the present affair as Riazul Haq.
So they have mentioned my name wrongly also, my lord. I have given Elias, my lord. My name is Elias. I have given my millet identity, my name in the millet, one order, work order millet, and also voter card. Kindly see millet, page millet 17. This is the official order millet to me, to Riazul Islam, Sohayo, Mankasar, Electrical Subdivision, APDC.
Mr. Third. Should I say Mr. or Miss? Because you
Hana,
have,
Hana,
you have abruptly changed the council.
no, actually, we are facing some problem. There is a, can Hana may be recorded.
Heard Miss
C Begum,
C.
C Begum, Tasneena Begum.
P. Begum, learned counsel for the petitioner. Also heard Mr. P. Bodhakur, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Riazul Islam alias Riazul Haq, who is apprehending his arrest in connection with South Salmara PS case number 361/2023 under section 419/420/406/409 of the Indian Penal Code. The gist of accusation in this case is that one, Mirazil Haq had lodged an FIR on 23/12/2023, before the officer in charge of South Salmara Police Station, inter alia, alleging that the first informant had deposited an amount of rupees 24,000 and 26,000 on different occasion to the present petitioner as the for depositing against the electricity bill of 30 consumers. However, the present petitioner has not deposited the same to the APDCL, and as a result of which the electricity bill of the said 30 consumers have been shown pending. Learned counsel for the petitioner has submitted that the present petitioner, who are you?
I'm Sahaya, Lordship.
You are?
As a petitioner is a regular employee of APDCL.
Is an employee of APDCL,
Yes.
and before the instant FIR, the APDCL, where is the FIR?
Page 14, my lord.
The subdivisional engineer Mankasar Electrical Subdivision had lodged an FIR against the first informant Mirazul Haq, inter alia, alleging that he misbehaved and verbally abused with the line staff of APDCL, and it is submitted that as a result of a counter blast against the said FIR, the present FIR has been lodged. Learned counsel for the petitioner has also submitted that the petitioner is an employee of APDCL and he would cooperate in the investigation if he is allowed to go on bail. On the other hand, learned additional public prosecutor has submitted that perusal of the case diary would be necessary, hence call for the case diary. In the meanwhile, considering the fact that there is a counter FIR filed by the APDCL against the first informant of the FIR filed against the present petitioner, the present petitioner, namely Riazul Islam alias Riazul Haq, is hereby directed to appear before the investigating officer of South Salmara PS case number 361/2023 within a period of 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest, in connection with South Salmara PS case number 361/2023, the above named petitioner shall be allowed to go on interim anticipatory bail of rupees 30,000 with one surety of like amount, subject to following conditions. Condition number 1 and condition number 2. Eto loilu.
On 7-1.
Let this case be listed again on 7th February 2023.
Duly obliged.
May I please, your lordship. 30th application, lordship. The case 9 is the FI lordship. One, 3% has been named lordship, 3 home guards were named in the FI lordship, and one of them has approached before this honorable court, and lordship are pleased to grant him interim lordship.
Where is the order?
Order lordship, I have annexed it on.
Otherwise, my lord, my objection is there in this
One
case
minute,
because
hold
they
on.
are the home guards, my lord, doing their duty in the railway platform and thereafter, my lord, snatching the, my lord, those, my lord,
Lordship.
golden ornaments and other articles from the, my lord, passengers, my lord. And
Okay.
thereafter they fleed away from that outpost, my lord. They are doing duty as security person and thereafter, my lord,
This
snatched
is the order lordship of the named co-accused lordship. He was granted interim lordship to appear
Two
before
accused persons have been,
3% lordship. 3 are
other
there.
2 have been
uh,
given interim
Lordship.
protection.
This is the 3rd person lordship.
although, my lord, parity cannot be a ground in this type of offenses, my lord.
Same FI lordship, same person, same on duty lordship.
They are
Well, if
doing
the CD
duty in
comes-
that outpost, my lord.
Though case was listed on 18/12 lordship, CD was not there lordship. Now presently the case is fixed on 29/1 lordship.
The FIR only suspects that they are.
That's because they were not found at the duty time lordship. That is the
Therefore,
allegation
there
against
is
them.
a suspicion.
If they have not done anything, then why they fleed away from that outpost, my lord?
বেলেগ কাৰণত যাব চিঠি খন আহিল ইঞ্জিন দুটাত আছে 3
Okay,
নম্বৰ
heard
মানুহ।
Mr. S. Munir, learned counsel for the petitioner, also heard Mr. P. Bhattakar, learned additional public prosecutor. Yarpa court koribo, court remaining portion from AB application number 3914. Lavanita, yeah, I have flagged it. 3914, remaining portion, accuser naam change koribo, remaining, everything will remain same. 30,000 with one surety within 10 days. Next date is 29/1. Case diary for
Yes.
10 days, lordship, the 5 or 6 days will be one lordship because of the certificate to be might not be lordship. But 10 days lordship will be.
10 days.
Much obliged, your lordship. Much obliged. Much obliged.
Yarpa court koribo.
May it please your lordship. Lordship, this is a 438 bail application, lordship, 75 years old lady, lordship, before your lordship. His apprehension of arrest in connection with lordship, Tamulpur PS lordship, the case, FIR lordship will find on page 10 lordship. The age proof lordship, that is Aadhaar card on page 16 lordship.
What is the allegation?
Allegation lordship against this petitioner lordship is that he has demanded dowry lordship, but subsequently lordship the informant sister lordship found death by hanging lordship. That is the allegation lordship. But this lady is a 75 years old lady, and she is the mother of Gayaram Das, who is the prime accused in this case lordship. 3 years ago, they got married with the informant sister lordship. Now this 75 years old lady, she is not in a physical position. Not in a
Whether
physical.
will you appear before the IO?
I'm ready to appear, lordship. I'm ready to appear, lordship. 75 years, lordship, she can appear, lordship.
Well, this incident happened, my lord, within a short period after marriage, my lord. So at
That is
this case, there would be required, my lord.
But the lady, lordship, considering the age, lordship, 75 years, lordship.
Let us see.
Yes, my lord.
Let she appear. Considering that she is an old lady. Heard Mr. B. Chaudhary, learned counsel for the petitioner, also heard Mr. P. Bhattakar, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Srimati Charubala Das, who is an old lady of 75 years of age and who is apprehending her arrest in connection with Tamanpur PS case number 282/2023 under section 304B/34 of the Indian Penal Code. The gist of accusation in this case is that on 30/11/2021, one Sujay Biswas lodged an FIR before the officer in charge of Kumarikata Police Outpost, inter alia, alleging that the sister of the informant was married to one Gayaram Das, who is the son of the present petitioner. And it is alleged that after the marriage, the husband of the husband of her sister, as well as the family members, other family members, including the present petitioner, subjected her to cruelty and demanded dowry. And ultimately, the sister of the first informant committed suicide on 29/11/2023. Stop. Learned counsel for the petitioner has submitted that the allegations leveled against the present petitioner in the FIR are not true. It is also submitted that the petitioner is an old lady of 75 years of age, and in support of her age, what document have
It's a Aadhaar card, Lordship, page 16.
the
Lordship.
Aadhaar card of the present petitioner has been annexed as annexion number 2, wherein her date of birth has been shown as 1/10/1949. Stop. Learned counsel on the other hand, learned additional public prosecutor has submitted that the death of the deceased had occurred within a very short period of the
Within 3 years.
marriage, and therefore he submits that perusal of the case diary would be necessary. Stop. Hence call for the case diary fixing.
On my lord, 6-1.
6-2. However, considering the fact that the petitioner is a lady and that too an old lady of 75 years of age, she is hereby directed to cooperate in the investigation and in the event of her, you need not to appear. Let the IO.
Yes.
And in the event of her arrest in connection with
Tamalpur PS case number
Tamanpur PS
282.
case number 282,
Public 2023.
public 2023, before arrival of the case diary, the arresting authority shall allow her to go on bail of rupees 30,000 of one surety of like amount, subject to the satisfaction of the said arresting authority with following condition. Number 1, number 2. Interim bail. Number 1, number 2. Let this case be listed for case diary again on
6-1.
6-2.
Highly obliged. May it please your lordship. The petitioner before lordship, my lord, he is an additional chief engineer.
24 with the.
Oh, won't you believe? 25 inside.
Anyway, I'm not talking about. Lateral loss. But 366, 34. All the feminines against, allegation is against petition number 1. Basically, allegation is that they have come and taken the girl, and ultimately she was recovered through the police. Now she is with the parents, man. So the custodial interrogation is required. This is the only case, my dear. From the FIR itself, on page 10. Age is also not given, my lord. Only simply say minor daughter Miss Sukina Begum from the year so and so took her away. Accused person kept my daughter with accused number 1 at Chowk to get her married to accused number 1. I contacted the accused person, but as they did not return my daughter, on 27/11/23, I got my minor daughter recovered by the OC, Moirabari Police Station. The lodging of the FIR got delayed as my daughter was unwell and
After perusal of the case.
but others, number one, I understand my law. Other father, mother and my law, father's mother-in-law, that maternal uncle, maternal aunt, maternal. Except one, I think, my lord, your worship, one of course, my lord, I lift your worship, my lord. Otherwise, in the custody, already she is recovered, my lord. Nothing happened. No allegation of 376 also. Others, my lord, I think, my lord, only petition number.
No, the allegation is against all.
Basically, no, that is there, but basically, if he kept her in the Chongi, my lord, allegation, others, my lord, your worship will see whether simple because of that one.
And
No, only ladies now.
Only ladies, my lord. One lady, petition number 3.
3 and 6.
3 and 6.
3 and 6.
I lift your worship, my lord.
Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr.
Islam.
A. Islam, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Is it okay, Mr.
no,
Parashar?
my lord, my lord.
Heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been preferred by the petitioners, namely number 1, number 2, number 3, 4, 5, and 6, who are apprehending their arrest in connection with Moirabari PS case number 253/2023 under section 366/34 of the Indian Penal Code. The gist of accusation in this case is that on 30/11/2023, one Ruhul Amin had lodged an FIR before the Superintendent of Police of Moregaon District, Inter alia, alleging that on 26/11/2023, the accused persons named in the FIR within bracket the present petitioners came in a four-wheeler vehicle and kidnapped the minor daughter of the informant and took her away to get her married with the accused number 1, with the petitioner number 1, namely Rafiqul Islam. However, it is also submitted that on 27/11/2023, the minor daughter got recovered. However, she was found unwell. Stop. Learned senior counsel for the petitioner has submitted that what is your submission?
My submission, my lord, because nothing happened, my lord. 366, she was recovered safely, my lord.
As the victim has been recovered, there may not be any requirement of any custodial interrogation in this case, and hence anticipatory bail is spread for all the accused, all the petitioners. On the other hand, learned additional public prosecutor has submitted that considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary. Stop. I have considered the submissions made by learned counsel for both the sides. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence call for the case diary fixing.
Medical report and 164 statement, my lord, along with
Fixing date.
29, my lord.
Fixing 29
of-
1 for case diary. However,
Nice.
in the meanwhile, considering the fact that the petitioner number 3, that is Noor Banu Khatun, alias Noor Banu Begum, and petitioner number 6, that is Eliza Khatun, alias Eliza Begum, are women they are allowed to, so they are allowed to appear before, they are directed to appear before the investigating officer of Moirabari PS case
18,
number
19, 22 বহুত হবে। 18, 19,
253/2023 within a period of 10 days from the date of this order. And if they do so within the stipulated period of time, comma, in the event of their arrest in connection with Moirabari PS case number 253/2023, both the above named petitioners shall be allowed to go on interim anticipatory bail by the arresting authority subject to by the arresting authority with bail condition of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions, condition number 1 and 2. Let this case be listed again on 25/1.
Made to the law. My lord, the petitioner is an additional chief engineer, my lord, under the government of Assam. Kindly see the allegation, my lord, at page 18, FIR. I think, my lord, the new offences are in the making, my lord. That this in reference to the lordship's got it, my lord. Page 18. This is in reference to the direction received from district commissioner to file FIR. So, my lord, there is a direction by higher authority in the matter of making illegal profit by selling of government land by Kuldeep Das, a government servant, in the rank of executive engineer on the basis of inquiry submitted by Vikram Setri, ACS, additional district commissioner, so and so, so and so. That it has been revealed during the course of aforementioned inquiry report, Kuldeep Das had purchased the possession of a government land measuring 10 lessa covered by government DAG number so and so from Purno Boro, so and so, Purno Boro Das, wife of Dipankar Das, in Fotasil for an amount of rupees 7,50,000 in 2019, and subsequently sold of the said land in 2021 to Dildar Hussain for 17 lakhs by of an unregistered sale deed, thus making a substantial profit which is not legal. Well, I am yet to come across this type of an affair, my lord. Actually, my lord, what had happened, I bought some possessory right. I constructed boundary one and all. So I spent some money.
No, what under what provision it has been registered?
Section under, my lord, 120B, 420, 467, 468.
420 and 467, 468, how it comes?
Oh, my lord, is it the allegation of any private
That
party?
he has sold it, saying it to be.
Lord, I have purchased a plot of land, I have sold it. That's my only offense. And I'm an additional chief engineer of government of Assam. In fact, my lord, under some mistaken belief, my lord, I purchased this land. It turned out that, my lord, actually the seller had no title. I'm facing another proceeding from the municipal corporation, my lord. Because I have constructed the house, I'm not getting the permission. Some higher officer has directed, therefore this case has been raised.
Now, what is the submission?
My submission is, my lord, it doesn't make out any offense. I can come for quashing, that's a different thing, my lord. End of the day, I'm a government servant, my lord. I'm a senior government servant.
No, at this stage, my lord,
Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr.
DJ Das.
DJ Das, learned counsel for the petitioner. Also had Mr. K. K. Parashar, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Kuldeep Das, who is apprehending his arrest in connection with Gorsuk PS case number 8/2024, under section 120B/420/467/468 of the Indian Penal Code. The gist of accusation in this case is that on 28/12/2023, the circle officer of Dispute Revealing Circle had lodged an FIR before the officer in charge of Gorsuk PS case number, Gorsuk Police Station, inter alia, alleging that on the basis of an inquiry report submitted by Shri Bikram Chhetri, ACS, additional Deputy Commissioner, Kamrup Metro, it came to the light that the present petitioner had purchased a possessory right of a government land measuring 10 bighas,
10 lessas, my
10
lord.
lessas, covered by government dag number 5432 of Revenue Village, Sahar Fatasil, under Beltola Mauja, Sahar Fatasil, under Beltola Mauja, in Dispur Revenue Circle, from one Srimati Purnima Boro, Purnima Boro Das, and Dipankar Das,
Wife of Dipankar Das, my lord.
and
Dipankar,
and
yes.
Dipankar Das, for an amount of rupees 7,50,000 in the year 2019, and subsequently sold off the said plot, said land to one Dildar Hussain at an amount of rupees 17 lakhs by way of unregistered sale deed, thus making substantial profit, which is not legal. What is this reference para number?
My lord, that's the report of the Chhetri,
Which
that
is not
Bikram
le-
Chhetri.
which is not legal according to the inquiry report submitted by the additional deputy commissioner. Stop. Learned counsel for the petitioner has submitted that the petitioner is an additional
Chief engineer,
posted
Barak Valley, my lord, Silchar.
posted presently at Barak Valley, Silchar, and he had purchased possessory rights of the land in question and subsequently sold that possession.
After developing the land.
After developing the land, sold the said possessory land rights to the
One Mr. Dildar.
one Dildar Hussain. Learned senior counsel for the petitioner has submitted that bare perusal of the FIR would show that no offense is made out under section
420B.
420B,
120.
under section 120B,
120B,
420/467/468 of the Indian Penal Code. However, as police is searching him, he is apprehending arrest in connection with this case. On the other hand,
It is because, ma'am, let him.
learned additional public prosecutor submitted that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Fixing February 1st.
5th of.
Fixing 5th of February.
My lord, could it be after 8, my lord? For a few days, I'll be not absent.
12.
Fixing 12th of February. However, in the meanwhile, as apparently it appears that no offense has been alleged in the FIR against the present petitioner, the present petitioner is hereby directed to appear before the investigating officer of Gorsuk PS case number 8/2024. How many days?
10 days.
Within a period of 10 days from the date of this order, and cooperate in the investigation. if he does so within the stipulated period of time, comma, in the event of his arrest in connection with Gorsuk PS case number 8/2024, the above named petitioner shall be allowed to go on bail of interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number one, number two. Let this case be listed again on 8th of February. 12th February.
May I please have a project 430 reflection, your lordship. FIR lordship will find at page 8 lordship. But FIR indicates lordship that the petitioner along with his friend wearing helmet coming in at excessive speed from so hit a police personnel lordship.
You beat up a police personnel.
My lord, my lord, petitioner was in excessive lordship, speed lordship. So for instructed lordship, there was no barricade was installed lordship. And the home guard lordship, he suddenly came in the middle of the road lordship. And my lord, that's not intentional lordship.
They are coming without wearing any helmet. Because of that, police went to stop them.
Dear lordship, 279 is also dear lordship. We have inserted 279 lordship.
Yes, Mr. Parashar.
But that is there, but in the incident, might have got grievous injury also. So it can be revealed from the CD.
No, you hit the police
Yes,
personnel.
yes, hit the police personnel.
Hit.
Great.
Okay. But ignoring the signal.
My lord, actually, my lord, no barricade was installed, lordship. So for instructed lordship, and the home guard lordship, suddenly he came in the middle of the road, lordship.
And he was taken to GMCH for better treatment.
So that's purely accident case, lordship.
Heard Mr.
D. Bhuya,
D. Bhuya, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Khairul Islam, who is apprehending his arrest in connection with Hajo PS case number 430/2023 under section 279/307/326/34 of the Indian Penal Code. There was Naka checking. Let us call for the case diary,
Because
giving a short date.
left leg was fractured.
No, is it accidental case? If it is
No, during checking, and as they are coming without any helmet, because of that,
let perusal of the case diary would be necessary.
But no barricade was installed, lordship. Naka Singh, though it was Naka Singh, lordship, but no barricade was installed, lordship. Petitioner did not notice, my lord.
Let us see. We will give a short date.
22nd.
Considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary, fixing 22-1 for case diary.
Highly appreciated.
Maybe you lost it. In this 306 and 376, they are mother. What happened in this case? Your lordship will find date of occurrence is 10/10/23. And on 31st/10, they file a complaint with the magistrate without any affidavit. And the magistrate simply forwarded the police registered a case. Your lordship will find the allegation is page 9, my lord. You kindly see the vernacular portion. page 14.
What is the allegation?
Allegation, my
How
lord, your
she-
lordship,
she was
allegation
found-
says she is a married lady and her husband stays in Mizoram and she was having some relation with petitioner and ultimately, my lord, she wanted to marry him. He refused. And then, my lord, she committed suicide. This is the main, my lord, allegation. Your lordship. She is already married, my as per complaint, my lord. Already married, how can I marry her now? And your lordship will find what they're writing. On page 10, the accused person by taking advantage of our simplicity established love relationship with my daughter and by assuring her to marry establish physical relation with her against her will. As a result of which developed pregnancy. She is already married, my lord. The accused person refused to marry her. Then my daughter narrated the entire incident to her mother, brother. On being informed about the incident by them, I, along with my brother-in-law,
Yes, Mr.
spoke to
Farah.
the accused.
My lord, my lord, regarding that, but regarding physical relationship with the assurance of marriage, that is also there, my lord. 376 also there.
But page 9, second line, 3 years ago, my daughter was married to one Farooq Ahmad.
Yes, my lord.
How I can be the author of my pregnancy, my lord? Always she is married, how I can marry her, my lord?
Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. R.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Inzamul Haq, alias Inzamul Haq, who is apprehending his arrest in connection with Pathakandi PS
Pathakandi.
case number 324/2023 under section 120B/306/376/40417 of the Indian Penal Code. Inter alia in the Indian Penal Code. Stop. The gist of accusation in this case is that on which date you have lost the FIR?
Oh, the FIR was lodged on 31st/10.
On 31/10/2023, one Helal Uddin
Yes.
had lodged a complaint before the officer,
Before the magistrate.
which magistrate?
Yes. CGM Karimganj,
Before the chief judicial before the learned chief judicial magistrate
page 14, your lordship.
Karimganj, inter alia alleging that
Her daughter is married to one
her
Farooq Ahmad.
daughter who was married to one Farooq Chand
Yes.
came into contact with the present petitioner and
Established.
they established and they entered into physical relationship against her will though.
Yes, it is there against her will, man.
Physical relationship against her will, as a result of which the daughter of the first informant got pregnant. And thereafter, the petitioner refused to marry
My daughter asked the accused person to marry her and to take her to his house.
to marry her in spite of requests to marry her by the present petitioner. However, the petitioner refused to do so. And on 10/10/2023, the petitioner, the daughter of the informant, committed suicide by hanging. It is alleged in the affair that the daughter of the first informant committed suicide due to the acts of the present petitioner. Stop. Learned senior counsel for the petitioner has submitted that the allegations leveled in the FIR in the complaint are not true. It is also submitted that though the complaint has been forwarded by the learned Chief Judicial Magistrate Karimganj to the officer in charge of Patharkandi Police Station. However, the said complaint has not been supported by any affidavit. It is also submitted that the daughter of the first informant was already a married woman, and therefore the question of marrying the said lady does not appear. Learned counsel for the senior counsel for the petitioner has also submitted that though the alleged incident had occurred on 10/10/2023, however, the complaint has been lodged
After 20 days.
by the first complainant after lapse of about 20 days. Stop. On the other hand, learned additional public prosecutor submitted that the perusal of the case diary would be necessary for consideration of the instant petition, has hence called for the case diary fixing
6th of February.
6th February for case diary. However, considering the facts that the complaint has been lodged by the father of the deceased after a delay of 20 days and no allegation was leveled against the present petitioner by the deceased herself when she was alive regarding the illicit she was alive. Stop. And also considering other facts and circumstances of this case, the present petitioner is directed to appear before the investigating officer of the Patharkandi PS case number 324/2023 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest, in connection with Patharkandi PS case number 324/2023, the above named petitioner shall be allowed to go on interim anticipatory bail of ₹30,000 with one surety of like amount subject to the satisfaction of the arresting authority with following conditions. Let this case be listed again on 6/2/2020.
Might have 10 days further, we'll get copy today, or if it is not today, then I may be given more time.
10 working days. 10 working days.
10 working days.
Right, working days.
Item 63, no supplementary is.
For 38 application number. I take your lordship the FIR kindly see. It is a love relation, my lord, with the informant who is 28 years old lady. And in the very first line, it is respected submitted that I have love relation with Alauddin, but on 16/12/23, evening at 6 p.m. while I was
FIR
working at that time, Hanif Ali and Amir Hamza kidnapped me and took me at Sonaili Khola at the house of Hanif Ali and locked me in the house. However, at 11 p.m., Said Alauddin established physical relation with me in the house of Hanif. After that incident, Fakir Ali Diwani came and in association with the other accused took ₹70,000 from Alauddin and paid 9,500 to me, but the amount was taken back from me. They threatened me and said that if the informant police, then I will be killed. I did not know, did not go to the police station out of the because of which there was a delay of lodging. After 5 days, my lord, the FIR was lodged. Case has been registered under 420, 376, 366, 506. Now, my lord, from the plain reading of the FIR, it does not disclose that there was any 376 or any other material. She is a very
Alauddin established.
Yes, but Alauddin is the with whom her relation is there. She has admitted in past.
But still, Relationship is there, but she has alleged that forceful physical.
376 against Alauddin and against Hanif and Amir Hamza 366.
Oh my God, there is no allegation of the forceful rape. That the relation. He has established physical relation. And he said that they are in relation. And on that day she came out. And now this is the second story. She has jolted the whole thing. There is something fishy which was the generation of 70,000 and she took the 9,500 again returned back. Why all these things, sir?
My lord, vernacular page.
No,
page
in
14.
vernacular, the
Yes.
translation is not proper.
I'm reading.
তলা বন্ধ কৰি ৰাখে আৰু
You have
11
not
বজাত তালা
properly
হানি
translated.
পেলাই মোক ধৰ্ষণ কৰে। So,
ধর্ষণ করে কি forceful
Dhorkhan
physical relation
means
is also not
forceful.
forceful. He said we are in love.
my lord, let the 164 come.
My lord, Dhorshon is the word which we are using the this newspaper or somewhere.
It is
But-
not forceful.
But when she said that I am in love relation with him
Maybe,
and she came back and
maybe,
there is a transaction of 70,000. She took 9,500. Why all these things have come?
but she has alleged that she has been raped.
She has jealous matter because of the monetary transaction. She said that 9,500 was given to me, but
Yes,
it's taken
ma'am.
back.
Is there in
Give me some protection, my lord. Kindly call for the city.
This is not,
Something fishy, my lord.
this is not a case of interim protection.
But it is a case for interim protection because her allegation is not very convincing. Mere saying that I have been a dharshan koriche, will lordship accept it?
against Alauddin, Hanif and Amir Hamza. These three, my lord,
But at the very beginning of the FIR, she said I am in love relation with Alauddin.
maybe against wife also, my
Now
lord.
let the Alauddin remain, others will be granted, my lord, considering.
Not now.
Others may be considered, my lord.
Heard Mr. S.C. Vishal.
She has not narrated everybody's name. She has left out some names.
Let us peruse her 164 statement. Heard Mr. S.C. Vishwas, learned counsel for the petitioner. Also heard Mr. P. K. Parashar, learned additional public prosecutor. Considering the nature of allegations leveled against the petitioners in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary fixing
29, my lord.
29.
But Bongaigaon, Manikpur, very near, my lord. Let it be 20th, 19th, my lord.
No, 19 not possible.
18 kindly.
18 not possible. Today it will go and 18.
Along with the medical report, my lord, kindly.
Along with the medical report.
25, my lord.
24 for a minute. 24 বন্ধ আছে না?
Okay, 24-1 for case diary.
24. My lord, notice to the respondent. Two.
Yes. Issue notice to the respondent. Number 2,
Steps to level লাগিব এতিয়া।
the petitioner shall take steps
I'll
for
put it-
issuance of notice to respondent number 2, according to the procedure led by this a division bench of this court in Deepak Nayak versus State of Assam. The petitioner to take steps within 3 working days from the date of this order.
Biplab.
64.
Here application lordship. Lordship, this is the case lordship. 2 FIR was registered lordship in the lordship case 325 and 324 lordship. In both the cases lordship, I have FIR in person lordship. The Anin Musahari lordship. On page number 15, there is an FIR lordship. 325 lordship.
One case diary is you have given inside.
My
This
lord,
is that land scam.
Dorso
Yes,
325.
that's case lordship.
Dispute
regarding dispute 384 and crime.
prime master.
Separate.
This is a different
This
matter.
is one.
Okay.
325 lordship.
Dorso 325. And specific allegation regarding Anil Musahari, my lord.
Lordship, in this
Para
case, lordship, as in my submission, lordship. Lordship, my name includes this case, lordship. I am the person, lordship, in that very locality, lordship, from all times, lordship. Here the thing is that, lordship, we are the person who developed that very land, lordship. Here the thing should comes out in this case, lordship. My name only, lordship, only having a relation of the another person whose name in the FIR, lordship. Here, many times city calls it the case, lordship, but nothing should be recorded having a section ID 468, 379
In
for anything,
this,
lordship.
in a connected case, whether case diary has been called for.
My submission is only for this lordship. In this case, lordship, though I am a FIR name person lordship, my only for the meantime lordship, protected me lordship, I appeared before the IU lordship because my statement is very necessary in this case lordship from my side lordship. Because my involvement in this case lordship only having a thing of enemy lordship. Because I am with maybe that very person lordship, though having the against person after the informant lordship. But thing is that lordship, my necessity is that lordship, if I appear before the IO concerned lordship, many things should be disclosed lordship. Only having a reason is that lordship, I am a FIR name person lordship. This is not a thing lordship. But the thing is that lordship, here lordship, many things is my concern lordship regarding this case. Not only 325, this to 324 also their lordship. I have to apply lordship. After that lordship, by requiring statement lordship, call for the city leadership. If allegation is there lordship, reject the bail petition lordship. My simple submission is that lordship. This is not having a section of only in the case of 325, 324 also their lordship.
Short date may be given on the 22nd,
Regarding his interim prayer.
No, at this stage, I am opposing.
Because there is several times city disclosed in the court lordship. Anil
Because-
Kusahari name is not come
No,
lordship.
no, I have lost track of other cases. In some cases, even police custody has been sought for,
Yes, lordship.
and police custody was granted to some of the accused. Under that
Yeah, this is different
circumstances,
case.
without perusal of the case diary, interim
difficult,
protection, I think it is difficult.
Just one line lordship, I have to say lordship. Here my submission is only for this lordship because my name is in both the cases in the FIR lordship. The thing is that lordship, only having a reason of that lordship, my name is in the FIR lordship. Here many persons lordship,
We are
even
fixing
a
a-
person lordship. I have annexed an order lordship, even a person Sumit Boru lordship, though he is not mentioned in this FIR lordship, but in 324, he is getting the benefit of the previous bail lordship. Sumit Boru lordship. He is getting the benefit under 18-1 lordship, his matter is fixed lordship. My submission in that lordship, how my involvement in this case lordship, only one chance should be given lordship. Even tomorrow also lordship, I appear before the IO concerned lordship. After this short date should be given lordship. That will support my part also their lordship in the city. Whatever documents I have lordship, I will deposit in the IO concerned lordship. Only for that lordship I am concerned.
Mr. Parash.
That is lordship 324, this
Yes,
is
lordship.
325. Best on 22nd,
Because from same my thing is that lordship, if I am not appearing before the pursuit of the city lordship, my bail is rejected lordship. The thing is that my part should be have submitted and that thing should be comes in the city lordship. Only have submission of that lordship. Only give me a chance lordship that I appear before. I am not becoming the absconding lordship. I just want to become the lordship for a few days. I appear before the IO concerned lordship and after the pursue the city lordship. Humble submission lordship.
No, what materials are there against you, we do not know.
That's why, lordship, I want to appear with. I have a document something, lordship. I deposit there, lordship. And that will help in the city, lordship. By my side, lordship, I'm submitting the same lordship. Because
And
still,
some of the accused, who are the other co-accused?
lordship,
Some of the accused are still under detention.
Lord Sumit Boru, lordship, is getting the benefit of 324, lordship. He stated there, lordship, because 324 same as 325.
No.
Either is another case, we have to.
Heard
the
Mr.
city.
Heard
N. Dubey,
Mr.
lordship.
N. Dubey, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Though learned additional public prosecutor submits that the perusal of the case diary would be necessary, considering the nature of allegations leveled in the FIR and considering number of similar cases pending even before this court, and as well as two other connected cases pending before the pending against the present petitioner also. Learned learned counsel for the petitioner prays for allowing the petitioner to go on interim bail in the meanwhile. However, this court is of considered opinion that perusal of the case diary would be necessary for considering the instant bail application. Hence, all for the case diary, fixing 22-1 for case diary after perusal of.
May I please your lordship? No, I had no, they mentioned, my lord, for upgrading item number 40. But what happened in this case, this boy, my lord, this young boy of 18 years, he is under custody since the last 40 days. He is a student of BCA examination, which is due to commence from 20th of January, my lord. And my lord, in another, the same case, my lord, another case, yesterday, he has been released on bail, my lord, from Tezpur. The ingredients under which this, my lord, case has been registered is absent, my lord. So kindly allow me to, my lord, give it.
Mr. Parashar,
CD not available.
when is your examination?
From 20th. 20th.
Okay.
Because I've seen the last
Item-
14 days,
item
my
number-
lord, I am in jail, my lord.
40.
Item number 18 flag kori chamber deba. I'll go through it.
Yes.
If I feel that
Item number
there is a case.
40.
Item number 30, my lord.
No, no.
Today is the third time, my lord, this series failed to produce.
এখন
So,
লগত
my lord, my prayer is this, my lord, already 54 days behind the bar. And without any allegation made out in the affair, my lord, only mere of suspicion. So, my lord, if it is possible, my lord, lordship can see the, my lord, things in the court. Otherwise, my lord, they may fix on 22nd.
20 seconds.
My lord, may I make a prayer, my lord? I mentioned it, you didn't reach, my lord, I'm very happy, my lord. Only thing, my lord, there is a single bench on 18th, my lord. On 18th, my lord, lordships, my lord. Because the others have been granted bail, exactly from the same car Caesar was bail, exactly the same situation. Can it be before your lordships? Item number
No, no,
69,
No tagging.
my lord.
Not before me, before any bench which is.
No, my lord, it has been placed before your lordships by the other coordinate bench. Because an apex court has said, my lord, once it is disposed of an bail application, my lord, the others should be tagged together. Somebody showed it, my lord, to that bench. Otherwise, it would have been disposed of yesterday itself, my lord. So it came before your lordships. I mentioned it, it didn't reach, my lord. Let it reach on 18th, my
So
lord.
where is the order that it should come before me?
In the item itself, my lord. Item number 69, can it be looked into, my lord, once, my lord? Item number 69, my Adil. 69 to Diokabad.
Maybe fix on 18. His prayer is for listing on 18.
It can be 18, but no fixed code.
No,
Registry.
my lord, it is, no, otherwise it will go to some other bench again. So, Lordship, but kindly look it up, my lord, that record. My lord, 1 second, my lord. Lordship would not take it otherwise, my lord. Why it has been done, that I also don't know, my lord.
Right, Hisab Hassani.
লেখা আছে না? Because Lordship passed that order, my lord, because of that reason, possibly, my lord.
Yes.
My lord, only one line may be added, my lord, in presence of that, my lord, NCB council, yes.
No. This is the order of the Chief Justice. So it will automatically come before my court. So I'll only mention that listed before 18th.
Exactly, my lord, it will be on 18th, my lord. My lord, today, yesterday also the NCB council was absent. Then I will not get, my lord, today also he is absent. Somebody else is on his behalf.
Instead of 18, it may come up before any other.
Well,
on any other date also. It will come to my court only.
can it be on 18 because he is languishing unnecessarily, my lord.
Okay, on 18th.
18th, my lord.
Item number 70. CD is here, Lordship, on 18th, Lordship. 70, Lordship. CD is here, Lordship, on 18th, Lordship.
Can you listen?
My lord, item number 51.
Oblige, my lord.
Item number 51, there is an interim order in respect of, my lord, petition number 2 and 3. Interim order may be like to continue.
70, Lordship, BA law. 70 to 80. Lordship, regarding.
My lord, item number 51.
Yes.
This matter may come up on 18th, on 19th, my lord.
18, similar situation may happen.
Then 19th, my lord.
What I suggest, you go through our board, dates available after
My
the room. Then court master, take time.
My lord.
Otherwise, every day, same situation, same
My lord.
thing will happen. You take dates as per your convenience,
My lord.
so that again you need not to mention at 4:30 PM.
And interim bill may be allowed to
Interim will continue wherever there is interim.
My lord.
My lord, item number 65 is the immediate next item, my lord. My lord, we just call for the case diary and fix any convenient date, my lord. That's my only prayer, my lord.
65 case diary, 22nd.
22nd. May I-
ID 68, Lordship.
No, if it is not covered by what I have already stated, that you take dates from court master.
Lordship, item number.
No,
Behind the bar, Lordship.
You have to, bar has to maintain a decorum. Let the senior should, if there is a mentioning that senior counsel should senior amongst you should mention.
Yes.
Otherwise, I will not hear anything. I will leave on it on the court master.
Item number 75, should I have mentioned that there is serviceman and that there is no interim order? Fix a date, CD may be detailed, Lordship. In 19, CD may be detailed.
90, item number 75, 19, CD may be
CD
written.
may be detailed.
Others, please.
My lord, item number 77, I mentioned in the morning to take it up at the last item because it is becoming infractious, my lord. It is an application for suspension of sentence under a Negotiable Instruments Act, my lord, and the petitioner is directed to appear before the trial court for surrendering.
77
Yes, my
flag করে ভিতর দিব. I'll go through it.
lord.
Lordship, my case may be fixed on 25th, Lordship.
Item number.
Item number 68, Lordship.
68, 25.
My lord, item number.
Others, please take date from court master.
My lord,
Lordship,
Obliged,
regarding
obliged.
73, Lordship, case diary is here, Lordship. Can it be on 18 or 19?
Court master will give date.
Lordship, 46 has already become infractious because FR has already been submitted. So keeping this matter pending.
Which one?
46, Lordship.
46.
FR number 10 of 2023.
Yes.
It was submitted on 30/11/2023. And I already confirmed it from the public.
26 on becoming infractious. it is
46,
disposed of.
46.
46.
46 on becoming infractious, it is disposed. of.
Lordship,
My lord,
item number
item
29 also search sheet has been filed, Lordship.
You have appeared. You are on interim.
No, Lordship.
No interim.
My lord,
Item number 29, the
Till date, Lordship.
the case is disposed of with an observation that
Till date, Lordship.
the petitioner may approach before the trial court and may pray for regular bail before the trial court if so advised.
CS number is 108/23, dated 31/12/23.
Till date, Lordship, I may be protected, Lordship.
No protection.
My lord, item number 31, 74 days in custody. CD was called, that is not received. May be taken on 20th, Lordship.
This I have already stated.
Yes.
Take date from court master unless it is extremely urgent where court master cannot pass an order.
Yes. CD also
On-
has not come, that is.
He will give a date. Anything else?
My lord, item number 52, my lord, in theory, okay, CD is available, my lord. No,
Take a short date.
no entry, my lord.
Take
So
it.
19 maybe.
Take a short date.